Faites l'appel, s'il vous plaît, monsieur le greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent.
Présente.
Monsieur le connétable de Saint-Brélade.
Présent.
Monsieur le connétable de la Trinité.
Présent.
Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Martin.
Présente.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Gruville.
Présent.
Monsieur le connétable de Saint-Ouen.
Présent.
Monsieur le connétable de Sainte-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le deputy Southern. Madame le deputy Labby.
Présente.
Monsieur le deputy Thadier.
Présent.
Monsieur le deputy Luce.
Présent.
Madame le deputy Doublé. Monsieur le deputy Morel.
Présent.
Madame le deputy Lehegara. Monsieur le deputy Ayer.
Présent.
Monsieur le deputy Ward. Madame le deputy Alves.
Présente.
Madame le deputy Gardner. Monsieur le deputy Gorst.
Présent.
Monsieur le deputy Farnham.
Présent.
Madame le deputy Moore.
Présente.
Monsieur le deputy Mezek.
Présent.
Monsieur le deputy Ozef. Monsieur le deputy Balash. Monsieur le deputy Coles.
Présent.
Madame le deputy Porre.
Présente.
Monsieur le deputy Wall.
Présent.
Madame le deputy Miles.
Présente.
Madame le deputy Scott.
Présente.
Monsieur le deputy Renouf.
Présent.
Madame le deputy Curtis. Madame le deputy Feltham.
Présente.
Madame le deputy Binet.
Présente.
Madame le deputy Jeune.
Présente.
Madame le deputy Miller.
Présente.
Madame le deputy Howell.
Présente.
Monsieur le deputy Binet. Monsieur le deputy Ferry.
Présent.
Madame le deputy Kovac.
Présente.
Monsieur le deputy Curtis. Madame le deputy Ward.
Présente.
Madame le deputy Wilson. Madame le deputy Stevenson.
Présente.
Monsieur le deputy Andrews.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi le gouvernement et les puissances de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, et de la conduire tellement toi-même par ton Saint-Esprit que toute leur délibération est accompagnée de ta bénédiction. Réussisse au bien-être et au soulagement du peuple, qu'il te plût de commettre à leurs soins. Car nous t'en prions au nom et par les mérites de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite sur la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonnons nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie point en tentation, mais délivre-nous du mal, car à toi est la règne, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le connétable de Saint-Hélier.
So the connétable was struck down with sickness last night. Could I declare him as malade, please?
Vous jurez que monsieur le connétable de Saint-Hélier est tellement indisposé qu'il ne peut pas assister aux États sans exposer sa santé.
Voilà.
Monsieur le deputy Southern.
I was wondering if Deputy Southern could be marked excused for the same reasons as yesterday, please.
Members content with marking Deputy Southern excuse as yesterday? Yes, excuse.
Madame la députée Doublé.
Defo.
Mallard.
Vous jurez que Madame la députée Doublé est tellement indisposée qu'elle ne peut pas assister aux États sans exposer sa santé.
Glad.
Monsieur le député Ward.
So I believe Deputy Ward is simply running a few moments late because of trouble with parking, but he is on his way.
Defo.
Madame la députée Gardner.
Defo.
Monsieur le député Ozef.
May I ask Deputy Ozef is excused for the same reasons given yesterday, please?
Members content to mark Deputy of excuse? Yes, excuse.
Monsieur le député Balash.
Yes, sir. I ask that Deputy Balash is marked as excuse for the same reasons as yesterday, sir.
Members content to mark Deputy Balash excuse? Excuse. Les États sont constitués. We resume the debate on the regulation of estate agents, and the next member listed to speak was Deputy Scott.
Thank you, sir. I just wanted to address some points of concern that were raised in the debate yesterday as in my capacity as chair of the Economic and International Affairs panel. The panel did lodge some comments in response to the Minister's amendment of this proposition and generally are supportive of the amended proposition. Concerns were raised by Deputy Ward regarding the redress schemes and where the money came from. I would refer him to those comments which mentioned that a number of estate agents are already members of a redress scheme in the island and generally pay a membership fee. The proposition itself, as amended, contemplates that the Minister for Economic Development or someone, depending on who, which minister carries forward this proposition, will be looking at the appropriateness of the redress schemes to be used for it. I also very much want to thank my predecessor, chair of the Economics and International Affairs panel and its former members for the work that they had done, and it was very good work on estate agent regulation. And pointing out that the panel, we generally do not look at private members' private propositions, but we did look at the Minister's amendment. I generally have expressed concern that sometimes when members do file amendments that they are proposing changes for which there hasn't been consultation. But it should be pointed out that Deputy Andrews' proposition does seek that there is consultation held. And as the panel has said in its comments, it does contemplate that perhaps certain concerns will come out that perhaps should be addressed. And possibly amongst them, the concern that regarding the qualifications of estate agents, which was something that the Deputy himself raised as a concern in a radio interview recently. It's one of those points that may well come out. Certainly in the finance industry, there are requirements that certain practitioners have qualifications, and one might question why that might not be the same here. And personally, moving on to what the Minister suggested, I do question whether it would be appropriate for the Minister for for the Environment to be taking this forward, because part of the concern here perhaps is that the industry is well regulated Yes, one does want to avoid more red tape, but on the other hand, there may be some in the market who shouldn't actually be there. We have a very tight employment market, and in fact, if it encourages some displacement and contributions in other areas, that may not be a bad thing. It's something that perhaps the Minister might consider as he does his further work. So thank you for listening, and the panel is supporting the amended proposition.
Thank you, Deputy. Connétable St Brelard.
Thank you, sir. I think with this proposition, I fear the unintended consequences, and we don't quite know what those are going to be yet. I'm never supportive of too much government interference in commerce and the increase in red tape, which tends to end up costing the client. And in this case, it seems to me that'll certainly happen. Down the road, sir, in a property transaction, there are others involved, of course, apart from the estate agents, namely the lawyers and the conveyancers. And I would ask the question of the proposer, is it intended that they be regulated in the same way as estate agents might be? The other point, sir, with regard to membership of associations, it doesn't always provide benefit to the end user, once again, and given that the body is UK-based, I fear that sanctions will be, as the Solicitor General said yesterday, they may have limited effect in Jersey. We have, sir, experienced as a deposit scheme being managed through the UK, which I know is a slightly different scheme, but the concept of it being managed in the UK isn't popular. So whilst I would support the last speaker having, from the scrutiny panel, supporting the proposal, and I will do too, sir, but I think we need to, I would counsel care in the way it goes, and let's look to the end user and not increase costs in a difficult market already. Thank you, sir.
Right up. Deputy Howell.
Thank you, sir. I think my points have been covered by Deputy Scott and the Constable of St Brillards. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on this proposition? Yes, Deputy Renouf.
Thank you, sir. I would like to make just a few comments. I thought I'd put it on and I actually put it off. Beg your pardon. Just a few comments. I must admit, in some ways, I find this a slightly curious proposition. I'm very pleased to support the more limited version of this proposition as amended. But the argument about the need for regulation is slightly more nuanced in my mind than perhaps in the minds of some contributors to this debate. Deputy Ward and the Constable of St Brelard have both expressed worries that the scheme may not be sufficiently Jersey-based or perhaps enforceable. I think my colleague, the Minister for Economic Development, before he kindly handed the job to me, made clear that there is work to be done and that considering the options include ensuring that a scheme is relevant in the Jersey and enforceable in the Jersey context. So I hope we can satisfy that requirement. Deputy Ward yesterday expressed that he doesn't like or had worries about the middle ground that is being pursued here, in the sense that we have accepted part of the proposition and not all of it. But I would say I do favour that middle ground with a redress scheme, but not as yet a statutory regulatory body. And I'd say that, sir, because it is striking that the evidence presented in support of regulation has made very little, if any, references to failures in the marketplace. I've read the scrutiny report, and there are 17 key findings listed. Not one refers to evidence of harm in the marketplace or presents evidence of failure. Within the report, reference is made to a public survey that included comments that were summarised as feeling misled by the buyer's estate agent and their lawyer, and unrealistic dates sometimes set by estate agents. It also quotes a figure of 86% of the respondents to a survey saying they supported regulation. It was a small sample, just 65 people, and looking at the detailed answers to questions, there were relatively few complaints. So I take it that most respondents were citing a generalised view that regulation would be a good thing, rather than something that was necessary to solve particular problems. Similarly, I've read Deputy Andrews' report. It makes no reference to consumer harm, lists no dodgy practices, and has nothing to say on how regulation would improve the consumer experience. In his speech, he slightly corrects this deficiency by referencing, I think I remember two things, asymmetric information and insider trading as complaints made against estate agents. In fact, made by estate agents, I think, against other estate agents. The final point I'd make, having spoken to officers who deal with complaints relating to consumer protection, is that I asked them to outline whether there had been complaints about estate agents. Indeed they have. In 2020, there were 8. In 2021, there were 13. And in 2022, there were 14. Those represented respectively less than 1%, 2%, and less than 2% of the total number of complaints received in the consumer division. And I would say also that those are very widely drawn, and not all would have been complaints. Some of them would have been inquiries rather than complaints. So I think that we need to be aware that what we're doing is not necessarily responding to an urgent need, but we're looking at what's best practice. So in the report, Deputy Andrews quotes me as saying that many estate agents already adopt good practice, and he says that this is unevidenced. I would argue the other way around, particularly based on the information I've just presented, which is that the burden of proof rests on those who wish to promote change. And in the absence of evidence that there are dodgy practices being pursued, I think it's reasonable to conclude that at the very least, that evidence is hard to find. Nevertheless, why is regulation of estate agents a good thing? The argument rests on 2 points. First, everyone else does it. And second, some estate agents, at least in Jersey, would like it. And both of these arguments have merit. We do need to be aware of what is happening in other jurisdictions, and that is why I'm very happy to support the amended proposition. So I am pleased that my colleague, the Minister for Economic Development, has brought forward an amendment that accepts the need for a redress scheme whilst rejecting the wider calls for a statutory regulatory body. A redress scheme is a good idea. It is not too onerous for estate agents. It provides an important and useful safety net and will give reassurance to consumers that there is somewhere to turn to if indeed they do have problems. In combination with our consumer protection law, this offers 2 levels of regulatory intervention. Now, it may be that in the future, further problems are identified that require further regulation, in which case I will be very happy to support them. So, sir, in summary, I'm pleased that we have found agreement on a sensible way forward, and it is a course I'm very pleased to support. And I will be happy to support further intervention if it is based on clearly proven need. Thank you.
Thank you, Deputy. Does any other wish to speak on this proposition?
Sorry, could we raise the defo on Deputy Ward, please?
Members agree the defo should be raised on Deputy Rob Ward. The defo is raised. Yes. Who's to speak?
Yes, please.
Yes.
I'll just wait for the conversation. That's all right. I know it's always good when you've had a defo raised on you, you feel the need to have a little chat afterwards. And thank the person who lifted it. Sir, I have no problem supporting this. I think it's right that the debate is centred not so much on whether we should have this, but what the nature of any regulation should be. And there are clearly different appetites in the Assembly which are reflective of the normal political spectrum as to what the appetite is for regulation. And we've already heard phrases like light touch, which I will talk about as well. And I'm reminded of the time when I was in a situation of bringing a somewhat similar proposition to do with the desire to regulate debt collection agencies. And this was something that I responded to because of several contacts that I had via email or via phone from constituents, and not just in St Brelard. And often what happens is that after the fact, you realise you tend to get to a position where you probably should have been in the first place. And it often is reactive, unfortunately. So this will all be on public record, and I'm not going to name any particular firms, but it seemed to be that there wasn't generally a problem in Jersey, but there was one particular firm which was causing clients particular grief, and that they weren't abiding by, this is what the complaints were, the normal expectation that most firms would automatically abide by, even though there wasn't a code of conduct. And I think the point we reached in discussion with the industry was that it was right and beneficial that there should be a code of conduct so that they knew what good looked like and they knew what best practice was, and that also the clients, whichever side they were on, whether they were the ones pursuing debts or being pursued, knew what the reasonable expectation was on them. And that seemed to certainly resolve a lot of the issue, because it was a wake-up call for perhaps that particular firm. And it also meant that any new firms coming into the industry knew what they had to do, and any clients knew what their rights were. And of course, I think this is where it becomes particularly important. Of course, when we talk about estate agents in Jersey, we can talk about those who sell properties for people. So they're dealing with people who want to buy and sell properties, but they're also dealing with the rental sector in many cases. So for housing for people who don't own their own properties. And I think that's in particular for me is an area of concern, because we're also dealing with situations where you have asymmetric power relationships. So you've got somebody who is a renter. I've been in that situation. I don't have any complaints about it particularly, but you hear all sorts of stories, and it's important, I think, that really this also needs to tie in with what's coming at the next session when we look at the residential tenancy law. And so when I hear phrases like light touch regulation, I think that's become a political mantra which some simply don't question. They say, oh, light touch, yeah, that's fine. That's what we want. I'm much more concerned about effective regulation. So I think any regulation needs to be justified, first of all. Secondly, if you are going to have regulation, it needs to be effective, and you need to know what kind of problem it is that you're trying to solve, or what kind of problems you're trying to prevent. And then this brings us to the next point, is regulation or just laws in general, should they automatically be reactive, or can they also be preemptive? So if we take ourselves back to an idealized form of society where nobody's ever been murdered, in the pre-Cain and Abel scenario perhaps, is it right to have a law that prevents murder? And, you know, religious people might argue that it's against the natural order anyway. There's a natural law that exists for that. But I would argue that even if there isn't a problem currently in the estate agent market, that doesn't mean that you can't have a code of practice there, which of course has been formulated by the very people who are going to be using this code of conduct day in, day out, and who are going to be potentially the recipients of complaints in that. I think that is something which I know from my brief involvement on the scrutiny panel. I couldn't do all of the scrutiny, unfortunately, due to family circumstances, but I know that a lot of work did go on, and I did read the documents, and that there is a general acceptance, I think it's fair to say, from the industry that they would welcome some kind of code of conduct, because most of them are doing that already, or aspiring to behave in a way which is good and best practice. So I don't think we need to over-egg the pudding on this one. I think we need to leave the space and accept the fact that we should have some form of regulation. And I will give a couple of tangible examples. I think it needs to go hand in hand with concrete practices which we generally think shouldn't happen. And I'll give one example. Some estate agents and letting agencies have a practice where they automatically charge for a renewal of a contract, even though a contract is a legal requirement. So if you're on a yearly lease and that's a rolling lease, as a tenant, depending which letting agency you're with, you'll find that you have to pay a sum of money, which could be anything around about £100, simply to be able to renew a contract, which you were going to do, and which is probably just a photocopy of a previous contract or something where the date's simply been changed by a year. Now, to me, that isn't good practice, and that isn't something that should be, that estate agents, letting agencies should be doing at all. And that is perhaps something which doesn't necessarily need to figure in the code of conduct, but it should somehow come about in the spirit of the code, because it isn't an onerous task. It doesn't cost a letting agency £100 to reproduce that. And from my experience, from dealing with somebody who was renting, found themselves in a situation where the flat had burnt down through no fault of their own, they then ended up in a situation where they weren't protected. And I think letting agencies can have a duty of care to make sure that all of their landlords meet certain requirements, not necessarily just legal requirements, but that there's a code of best practice to say that if you find yourselves in this situation and you let with our agency, you will have these protections, so both parties know exactly where they stand. And I think those are the real value addeds that we can have, if you excuse the slightly clumsy English, with this proposition. It doesn't just have to be a box-ticking exercise where we do the minimum, but I think we can be really proactive in having that conversation with the industry, with tenants, and also not forgetting those who buy and sell houses, because that can be a really traumatic time. And I'm not going to go into the areas of gazumping, etc., which I know are still a headache, because, but those kind of practices, if and when they do occur, sir, are not simply an issue that needs to be addressed by this code of conduct or by this form of regulation. It's something which needs to be taken into consideration, I think, in the round in terms of how properties go to court to be transacted, and also, again, what, if anything, the Housing Minister might have to say in form of more general regulation. So, for my part, I would have perhaps preferred the unamended version of this, but I think there is still scope if everybody goes into it with an open mind rather than preconceived ideas about light touch regulation. I think it could be a really good piece of work that we end up with.
Thank you, Deputy. Does any other wish to speak? Call upon Deputy Andrews to reply. Deputy Andrews.
Thank you, sir, and thank you to all the members who contributed in this debate. Sir, I know several members have raised some concerns about the redress scheme potentially being UK-based, or if it was, say, to be Jersey-based. I think the Attorney General provided some clarity, so I don't think there is really any need for me to provide any further elaboration. I think it's essentially going to be a mechanism that is going to be effective, and I think it's going to protect the consumer. And I think that is the most beneficial thing for the consumer here. Of course, as it currently stands, it's quite evidential to me in terms of the conversations I've been having with a number of estate agents that there is much that goes on that is not being reported. And I do believe this will remain an issue even with the redress scheme being in place. But for those who do report their circumstance to a redress scheme, at least we will see something that is enforceable, and we will see estate agents being held to account. And I think that is really important. Estate agents, they need to be abiding to a code of practice, and they first of all need to know what is being asked of them in their profession. Now, estate agents who are not members of a redress scheme and who are not members of Property Mark are essentially carrying out a service, and they have done no prior work to understand what is required of them in the work that they undertake. So there needs to be a change, and by supporting this proposition, we can actually allow for estate agents to understand what is being required of them with a redress scheme. Now, each redress scheme will differ, in the requirements that are laid out. Now, with the two redress schemes that were mentioned in the amendment, if you look at the website, there are different prerequisites, for instance, for estate agents to abide to. And this is for the minister, essentially, to consider if we are to use a UK redress scheme, probably going to be one of the two that have been mentioned in the amendment, or there is the opportunity where we could potentially see a redress scheme be incorporated in Jersey. Now, I know there was also mention about estate agents being professionally qualified, and this is still a view that I hold quite strongly. That is something that needs to be implemented in the future. Looking at the UK government, for instance, there's a paper that was, I think, released in 2019, and it's more specifically aimed at property agents, not estate agents solely, but it mentions the importance of having professional qualifications. And it was identified as well that there were a number of consumers who encountered property agents who, again, were not professionally qualified, who were not capable of doing the job properly, and therefore problems arose. So in the future, I do believe in the UK, if it's going to be a Conservative or a Labour government, there will be professional qualifications being introduced at some point. Now, if we, for instance, as a legislature, are to be bringing forward proposals to establish a statutory regulatory body before the UK, one could say, well, actually, we are doing the right thing. Others may say, well, actually, it's going to be an administrative cost. Potentially, there's going to be too much regulation, and that's potentially going to be a sentiment that maybe, say, some Conservative or centre-right politicians may hold. And I think the important thing here is you need to strike regulation with fairness here. And I don't think we can over-regulate estate agents by ensuring that they are qualified to undertake their role. And I think there has to be a transition for those who are working within the industry at the moment. And if, say, something was to come into effect in the future, we'd have to work with those estate agents to make sure that they are given a suitable time frame to become qualified, and those who already hold existing qualifications are going to be fine, and there's not really much work that needs to be done there. And for me, I think it's quite important as well with estate agents in Jersey that they are consulted. I think that's really important, especially with the implementation of the redress scheme, because we need to know what has their experience been like with the redress scheme, for instance, that they have been using. So members will be aware through the proposition and the amendment that members of Property Mark, for instance, also need to be members of a redress scheme. So I think this is actually going to allow us to see the difference in terms of those who are qualified, who are professionals, and who abide to a code of practice. And it's important to listen to those estate agents because they are the ones who've shared their experiences with me. And I think some of those experiences I was quite shocked by in terms of the malpractice that has been going on and the malpractice that has not been reported as well. And potentially that may be down to several factors. It may be down to fear, unintended consequences for the consumer. But today is the opportunity as an assembly, as a collective, where we can take a stand and we can say this is a step in the right direction. We can introduce a redress scheme, but also we need to be open-minded. And I do believe at some point in the future, there most definitely is a need to ensure estate agents, and maybe an extension, all property agents, should undertake professional qualifications. So thank you, sir. I call for the appel.
Thank you, Deputy.
Sir, just before the vote, could I ask that the defo is raised on Deputy Gardiner, please?
Members agree the defo be raised on Deputy Gardiner. The defo is raised. The appel has been called for. I invite members to return to their seats. I ask the greffier to open the voting. Yes, Deputy Watson. Right now? If all members present here or present remotely have the chance to cast their votes, then I ask the greffier to close the voting. I can announce that the proposition has been adopted, 42 votes for and 1 abstention.
Can I have the abstention, please, sir?
The Connétable St Clement abstained.
The next item is development levies, lodged by Deputy Kovacs, and the main respondent is the Minister for the Environment. Deputy Kovacs, there is an amendment lodged by the Council of Ministers. Do you accept this amendment?
Yes, sir, I'm accepting it.
You are accepting the amendment. Are members content for the proposition to be read as amended? The greffier will read the proposition as amended.
The States are asked to decide whether they are of opinion: A, to agree that a fair charging mechanism should be introduced to raise revenue for the States from any significant uplift in the value of land arising from when the land is rezoned or from when planning permission has been granted. B, to request the Council of Ministers to bring forward for approval the necessary legislation to give effect to the decision by the 31st of March 2025. And C, to agree that the proposals in paragraph A should also be designed to have the effect of capturing uplifts in the value of land arising between the date of the debate of the proposition and the coming into force of the necessary legislation, and to request the Minister for Treasury and Resources, having sought appropriate advice, to take the necessary steps to achieve this objective if possible.
Deputy Kovacs.
Thank you. Sir, I'm starting by saying I have no pecuniary interest in this proposition. I think everyone in the island, even children, recognizes the availability and affordability of housing is a very real problem. It affects people's lives on a day-to-day basis. Everyone needs somewhere to live, a roof over their heads, with the safety, security of tenure, a degree of comfort and privacy. It is a very basic human need. Within the above comes the mantra that cash is king and let the market force decide. However, whilst everyone is aware that this is the situation, then the only answer appears to be let's spend more money, subsidize, because thousands of people cannot afford the housing that they are living in. So this to me indicates a significant failure. The term affordable housing is a myth. Someone made it up. The assumption is that if you use it often enough, people will believe it. Well, thousands do not. They know the reality. The term affordable housing appears to have become a comfort blanket for politicians, not real people. It just became a phrase attached to political hot air, not in touch with the reality. So I believe that we need to do things by taking incremental steps in the housing market to really make a difference. With this proposition, I have deliberately avoided including my definition of an exact percentage or insisting that the levy receive this ring-fenced. I have done this so that this cannot continue to be an excuse for derailing the object of the proposal, which is to share by a significant percentage in the uplift in land value entirely due to states' planning decisions, dropping a windfall profit into the landowner's lap. So this proposition seeks to avoid any doubt. Members will see the content within my report. I have quoted extensively from a report and proposition from the former Deputy Wimberley of St. Mary. I have done so because when reading and researching background information, I found this very useful, but also disappointing that, in effect, nothing had been done. Everyone was content to look the other way. However, by doing this, it has not assisted in any way having more and truly affordable housing. From the Deputy of St. Mary's report and proposition P90 and PA147 from 2011, I wish to quote some of the content in the summary. This proposition is about basic fairness. When land is rezoned or receives planning permission, its value increases by between 80 and 200 times. This windfall gain goes only to landowners, and only those landowners whose land is developed. These huge gains have been going to the owners of land for years. It is government policy which has created these astronomical land values, and it is administrative decisions and political decisions taken as part of the planning process which decide just who it is who, in the Deputy of Grovel's memorable phrase, hits the jackpot. Like many other issues, this has been discussed for years. I believe it is high time that the government shares in that enormous windfall so that the revenue can be used for the good of all islanders. This proposition is emphatically not about the rights and wrongs of any of these zoning proposals or any other zoning proposals or planning permits. It is about the fact that in all these cases, the land involved changes enormously in value and the implications of this. At the stroke of a planner's pen, followed by a political decision, a resident becomes very, very wealthy. And in the island plan debate, we states members have the power to make, or in the case of some amendment, unmake millionaires. I think any right-thinking and sensible states member must see that there is something quite wrong about this. It should make us feel distinctly uneasy when the financial rewards of getting a permit for development are so enormous and are going to the very few. The situation is bluntly unfair and cries out to be remedied. The existence of this huge capital gain is due to the policies of government. It is therefore entirely right and proper that a large percentage of the capital gain should revert to the government, which created the policies which led to the uplift in value, to be used for the benefit of all the people of Jersey. So just to pull a few highlights from this report, I believe that it's worth repeating. It mentions basic fairness, been discussed for years, revenue being used for the good of all islanders, not a windfall gain to a few. So this is also worth quoting again. I think any right-thinking and sensible states members must see that there is something quite wrong about this. The question then is how this applies today to all of us. Seeing something is wrong, more importantly, being prepared to do something about it. We shall see. I have also in my report used reference to the involvement of Oxera, and they produced a report in 2005 and 2008 for any member who wishes to look into more detail. However, just to give members some flavor, I wish to quote from the same content. In Oxera 2005, page 57, we read, calculations by the states of Jersey estimate the overall uplift in the value of land recently reclassified from agricultural land to housing development land. Although subject to some uncertainty, the overall uplift in value amounted to around 32 million. In addition, a second phase of potential rezoning in the future is estimated to create a further uplift in value of up to 18 millions. On this basis, and given that the value of land is estimated to increase between 80-fold and 200-fold as a consequence of rezoning, there would appear to be significant scope for raising some revenue from the taxation of these gains. While none of this happened in secret, but in the full view of the public and politicians, no one believed it was appropriate to intervene and interfere with market forces at work or not. In the Deputy of St. Mary's report, he says, on an uplift of 50 million, a modest tax of 50% would yield 25 million over a period of years, a sum not to be sniffed at. And at this rate of tax, the landowners will still receive an unearned windfall of 25 million. I will repeat it. This windfall is entirely due to government decision and government policy, and is entirely appropriate that the enormous financial gain involved should come back, at least in part, to government. Members should note that the price of land does not drive the cost of housing. If it did, then it might argue that a land tax could affect the end price of housing. On the contrary, it is the end price which can be achieved which determines the value of the land. The end price reflects scarcity and the willingness to pay of enough people who are in the market for buying a house. This proposition is about finding a way to distribute a vast private unearned gain to the public good. So the questions are then about why nothing has been done by the states on behalf of the people to take a share in the windfall. It appears that the public, when consulted years ago, showed no opposition in principle to the tax, as an extract from the Deputies of St. Mary report shows. I now wish to demonstrate how certain things are said by the ministers, but the reality is nothing happened, no action. In response to the Deputy of St. Mary proposal in 2011, the then Treasury Minister said he was committed to review the land development tax option as part of the wider review of tax policy. This was highlighted in the comments paper to those proposals in response to the report and proposition from them. Work has already commenced on the development of this comprehensive fiscal framework, including establishment in 2011 of the Tax Policy Unit. The Tax Policy Unit is conducting a review of Jersey overall tax policy to ensure that it meets the needs of the island over the medium to longer term. Property taxes, of which land development tax is just one of a number of measures, are already being looked at as part of this review. The Minister for Treasury and Resources commits to review the land development tax as part of the wider review of tax policy. Despite claims that it was already being looked at, nothing happened. Only convenient delay for those who became windfall millionaires at the public expense. So there, I believe, is the evidence, abject failure, just standing on the sidelines doing nothing, no longer acceptable in my view, and I hope members will agree. With the current housing situation, I believe doing nothing is not acceptable. Finally, there have been other attempts to realize some of the capital gain in planning decision. Most recently, in a proposition from the then Minister for the Environment, Deputy Luce, in October 2017, when he asked the states to agree in principle to the introduction of an infrastructure levy in Jersey to ensure that those who benefit from an increase in land value arising from the award of planning permission make a small contribution to offset the impact of the development on the island community. However, this was narrowly defeated, although quite a few members did not register a vote. Contained with the report, with his report, it says, this mantle was taken up by the recent property tax review undertaken by the Treasury and Resources Department, which concluded that whilst there was no public appetite to capture sales value through the property taxation system, there was general public support to capture some of the increase in land value after planning permission has been granted. This again shows public support for sharing in the windfall for inflated land values. However, it also shows a political failing, not acting on evidence, not getting a public gain benefit. My proposition seeks to address this for future land sales, to address sales transactions. However, it will not capture the millions of pounds that showed previously have been collected. So in general terms, the amendments done by the Council of Ministers are acceptable, and I'm pleased we came to some form of agreement. However, I would qualify that by saying that in paragraph A, FAIR has a wide interpretation, and I hope all avenues will be considered for the best charging mechanism, not excluding possibility of tax can be found. In paragraph B, extending the deadline is a bit disappointing because opportunities could be missed to capture value for the people in planning gain, as indicated further in paragraph. And I hope the aim won't be that date as a final target, and in future as well, we can aim to do everything as soon as possible. And that's why by accepting the amendment in Part B, I then emphasize the importance of Part C, because in the existing Bridging Island Plan, in Appendix 1, around 40 million of land value is contained, and the charge on that value could greatly benefit the community and support with the housing situation. So I'm hopeful that by having introduced the words "if possible" at the end of it, would be a positive indicator for future action. Having said that, I do believe going forward there is a considerable public gain if this proposal is passed, and I ask members' support and I make the proposition. Thank you.
Thank you, Deputy. Is the proposition seconded?
Yes, sir.
Constable Greville.
Sir, I'm thinking only wise at this juncture that I declare a potential interest. I own land in the parish of Greville, and I feel that I need your advice on whether I'm able to partake in this debate and or allowed to vote in it. Thank you, sir.
Yes. Thank you very much. Well, this engages Standing Order 106. And members must clearly state the nature of an interest, which is the subject of a proposition. Now, I don't think that people who simply own a house need to declare that. But if you own a substantial amount of land which might be affected by this proposition in future, then you should declare that. But in my judgment, such members can still speak and vote. But under Standing Order 106.3, if you have a financial interest which is personal to you or shared with a small number of people, then you shall not vote on any proposition relating to the matter. Accordingly, if you own land which either will or may be rezoned as a consequence of the recently adopted bridging plan, or you know of a pending planning application or similar application which will have that effect, then you should not vote on this proposition. Is my ruling.
Can I just seek absolute clarity? So can I seek absolute clarity on that? That if you
Yes.
own land that has been rezoned in the Bridging Island plan, then you may not vote. But
Yes.
if you simply own land that at some vague point in the future may be brought forward for rezoning, then you should declare that interest, but you are allowed to vote, to speak and vote.
That's correct, yes.
Sir.
Yes. Any further questions before people make declarations?
Sorry.
Yes, who's allowed to start with? Deputy Miller.
So I'm sorry, if the land in question is unlikely to be rezoned, and what's the position there?
If you have a substantial amount of land, let's say several verges that may, in the future, be subject to benefit from this or subject to this, then I think you should declare that interest, but you may vote. Most members won't have that interest. If you own simply a house, you shouldn't declare an interest at all. And as Deputy Renouf has just encapsulated my judgment, if you own property which will be or may be directly affected by this as a consequence of the recently adopted Island Plan or the previous plan or some condition in the pipeline, then you should declare the interest and vote. Are there any more requests for clarification?
Please, sir.
Yes, Constable St Martin.
On behalf of the parish, Procurers and I in St Martin are negotiating to purchase a field for housing which was passed in the Island Bridging Plan. So I feel
Well, that's not a personal interest, though, is it? No, but thank you for mentioning it. That's not a personal interest.
Sorry, so similarly, the parish of St Clements owns a few fields. We're not about to make planning applications for them. In fact, we're buying these fields to do the opposite, to defend the building on these green fields.
Yes, well, that's not a direct personal interest.
Okay, thank you.
Yes, Chief Minister.
So simply for the sake of completeness, I think I do own several verges which feature in my declaration of interest, but I have absolutely no intention of ever applying for development of them, but I thought I should mention it.
Thank you very much. Yes, Deputy Legaré.
So similarly, I own a quarter share of a farm property which has agricultural land attached to it, and therefore will declare an interest.
Yes, Deputy Ferry.
Yes, sir. And in the same vein, I'm an owner of 2 plots of land in the parish of Trinity, sir.
Yes.
So may I declare an interest? I own a field and a small piece. I don't think it's a very large field and a small piece of woodland in Trinity. I don't believe it will be subject to rezoning, but I declare the interest, and it's now solely owned.
Thank you, Deputy Howell. Deputy Howell,
Oh,
your light
sorry,
on.
I'm the same as Deputy Legarat, that I own some land.
Yes.
But it's not likely to be rezoned. Thank you.
Deputy Tom Billet.
So if we're all having to own up, yes, I'm guilty of owning some land, so
yes. More?
Sir, I'd like to declare my confusion.
All right.
Following the statement of the Minister for the Environment, which you appear to agree with, as I understand it, or what as I understand it should be, that if somebody has land that is not in the built environment, because obviously if it is in the built environment, it's already capable of development. So if they have land like fields, this sort of thing, that aren't yet designated, don't have a change in use, then there is a potential for there to be a change in use and an uplift in value. If they do not intend to develop them, then I would expect there wouldn't be a natural conflict of interest. But if they have thought that of the possibility that they might or that sort of thing, then I would have thought there would be a conflict of interest and they should not vote. So could you please just be clear, because I believe that the Minister suggested the opposite, which didn't seem quite in accordance with my understanding of conflicts of interest and ethics.
Your understanding may be different from mine, but you must accept the rulings of the chair. And the ruling that I've given is that you have a direct financial personal interest and cannot vote if you own property which may be affected by the recently adopted Island Bridging Plan or a similar application. And if you simply own a holding in land of some significance, which may, in due course, in circumstances, be affected by this proposition if adopted, then you should declare that interest, but you may speak and vote.
So I would question, I don't want this to come across as questioning a ruling, but I think there is, obviously you've had this sprung on you, sir. I think there's a reason that we declare interest, and also in the written declaration of interest that members have, they say that they own land. Now, the whole point of this debate is it's future-proofing, because we don't know when land might be rezoned in future, especially the case if you own land in partnership with somebody else, like a spouse or family members. It may well be that they want to sell a field in 5 years' time, and the decision that we make today might mean that when members retire from this place, in future, they end up benefiting financially from a proposition that they voted on and spoken on today. And I think for it could be a matter of personal ethics, but I think one should always err to the side of caution and resolve any conflict of interest or potential conflict in the public interest. And I think the public interest would dictate that if you own big pieces of land in the green zone, naturally, they could at some point, especially given the fact that the island plan and future island plans envisage mass development of housing, not just in town, that those fields may well be given over to development in the future. And I think given the relatively small number of states members in this position in this assembly, compared to the fact that most people in the real world don't own fields, they may not even own their own flat, let alone vast swathes of field. It's one thing to say, I just want to keep this big field for my horses, but you don't know what's going to happen in 5 or 10 years' time. And so I would say, sir, that irrespective of the ruling, that members should consider on their own conscience whether they take part in this vote today.
Well, Dr. Teddy, I broadly agree with what you've just said, and perhaps I've adopted a cautious approach, but that's the approach that I've adopted. Yes. Deputy Rose Binney, do you want to make a declaration?
Yes, please. I'd like to declare that I'm a landowner, and I'm happy not to vote if that's preferred. I was actually going to vote for it.
No, you can vote and speak unless you fall within the limited category of persons to which I've referred.
No, I don't.
It's Contaverson.
No.
Yes, I do own some land as well. I also have an outbuilding for which I've obtained pre-planning advice, and for which my son is now going to submit a planning application.
Yes, but I think that means you can speak and vote.
Thank you.
Yes. Deputy Levy.
I am a usufructuary owner of land whereby there is a lifetime interest owner of the land.
Yes. Thank you. Conatava Trinity.
Thank you, sir. Just for completeness, I do own a small field which is attached to my property.
Deputy Rob Ward.
Yes, so it's not to declare I own anything, unfortunately. As if only, sir. It was just to ask a genuine question regards land can actually be rezoned at any time. And so it's not necessarily just a bridge and island plan. And I think it's part C that perhaps creates the problem, if I could get to it, but my computer's just switched off, which is the retrospective, well, it's not retrospective actually, it's future-proofing, which, I mean, I think is a very good idea, so that, you know, if this takes 4 or 5 years, we don't want to rush to sell land, and we won't get into debate now, but that could be very different for people, and I think that creates the difficulty here, that, you know, you never understand what's in the future, and I think there is an issue for people to think they may not be intending to benefit now, but it could happen in the future, depending on how the debate goes. That's all my
Yes,
concern.
but it will only be a direct personal interest which prevents them voting if either it's mentioned in the bridging plan or, as I've said, they're aware of a pending planning application outside the plan which may benefit that property and them. Yes, I think Deputy Mayor, you had your light on a while ago. Is it off now?
It is off. It's just to make some comments about, this is about zoning, not planning applications, sir.
Yes. Does anyone wish to speak on the proposition? Deputy Scott.
Thank you, sir. I'm sympathetic to Deputy Kovash's arguments and the proposition, but I would like to articulate a concern about the proposition as amended. I think it's a positive thing having the consultation, but I think it's also important to understand that as the Environment and now Infrastructure Department is currently structured, there is a potential for conflict here. And this is in respect to this reference to the Sustainable Communities Fund. Now, some people might actually think, well, this is great, the idea of having this development levy, particularly if you have fields that are going to be rezoned, hopefully create more social housing. Wouldn't it be great if those, if the proceeds of that levy could actually fund housing? It sounds very logical. And in fact, some political commentators have even suggested, why isn't government, when it rezones fields, doing something like compulsory purchase so it can actually build the social housing, or at least it might itself. The Sustainable Communities Fund actually is an infrastructure fund. And I believe that we should look back to the time when the States Assembly, or at least government, was suggesting an infrastructure levy, and a concern that was raised by the Jersey Construction Council at the time. And it pointed out that there was a difficulty there insofar as if government is going to benefit from a levy that actually enabled it to build infrastructure, then with the department structured as it is, you might argue that it could therefore want to disapprove planning applications and uplifts. It would have a motivation, and perhaps that might mean lead to positions where it doesn't seek to defend against the possibility of the spread of development as a result, which would be contrary to those desiring to preserve the environment. I'm conscious that the Minister for Environment himself has mooted the need for the Department for Infrastructure and Environment, or is it now Environment and Infrastructure, without housing, which of course has gone to the Cabinet Office where there's no conflict whatsoever, that he's actually mooted the need to decouple these two departments within the same department. And I do wish to point out that in the amendment that's been put forward by the Council of Ministers, it seeks a fair tax. I believe that it needs to be an ethical tax as well, one that is ethically fair. So I would ask the Council of Ministers who have brought this amendment to actually think a bit more about their leadership on conflicts of interest and how it might be improved, and to take forward these steps to resolve this conflict in the combined department. And subject to that, and in that hope, I will support the proposition.
Thank you, Deputy Scott. Does any other member speak on this proposition? Conatable Trinity.
Thank you, sir. First of all, just in my role as chair of the Planning Committee, the third paragraph of the report, and I know it's probably a play on words, but it does talk to rezoning by the Planning Committee for Housing. the Planning Committee don't rezone land. We interpret the policies of the Bridging Island Plan. But really, that's just a moot point. But speaking personally, obviously, I do support this proposition. It's something that I've thought about that should have been brought in before. When somebody stops growing royals and starts growing houses, there is this massive uplift in land value. But I just would err on a word of caution for unintended consequences, because my experience of landowners in Jersey is that they attach a value to their asset. And if they're not going to achieve that value when it comes to selling that asset, they may decide to stick it in the bank and leave it for later, unless they desperately need the cash. And as a consequence of that, it may in turn and inadvertently limit the land that comes forward subsequently for development. So I would say that I do support and will support this proposition, but I just there is a word of caution that we don't actually do something which is actually going to restrict the flow of land which comes forward for development. Thank you, sir.
Thank you, Conrad. Deputy Morell.
Thank you, sir, and I agree fully with Conrad Trinity's comments there. Similarly, I'll be supporting this. I was quite frustrated when we debated the Bridging Island Plan that a similar proposition didn't accompany that debate. But I just wanted, again, with a kind of note of caution, I just wanted to highlight in Part A where it says, when any significant uplift in the value of land arising from when the land is rezoned, that I understand, or from when planning permission has been granted. And I think there it's a question of scale, sir. What is a significant uplift? Some people's minds that might be £2,000 or £3,000, and other people's minds it might be £200,000 or £300,000. And so, I think to the many planning applications that I saw when I was also on the planning committee, people adding a small extension to their property, people turning one room into another type of room, things like this. If such applications, such works on people's land, their properties, were to be caught in this, I think that would be a very, very dangerous place to go. And to be honest, I think it would be deeply unpopular with the vast majority of people in this island. So I personally feel quite comfortable with the land rezoning element. I'm not so comfortable with when planning permission has been granted. And so I just ask that the proposer grants whichever minister develops this into legislation the leeway to act around that planning permission element, sir, because I think there could be some serious unintended consequences if planning permission, which is permission that anybody who owns a property, might just want to make small alterations to their house, which happen to then have an increase. Because even just establishing the value of that increase could be incredibly difficult. So I think that's a place that we shouldn't go, sir, and just stick to the rezoning. Thank you.
Thank you, Deputy. Conrad Harbison, Peter.
Thank you, sir. I'm going to be very brief, actually, but I'm happy to support Part A and B of this proposition. However, Part C introduces, in effect, a retrospective element. And I think that would be extremely unfair because I don't think it's normal to attempt to backdate legislation to the date on which we've debated the proposition. That would encompass land that we rezoned in the Bridging Island Plan. And at that point, of course, no such legislation existed. And I cannot support a bit of legislation that incorporates a retrospective element. Thank you very much.
Thank you, Conrad. Deputy Sadia.
Thank you, sir. I think this proposition touches on some very emotive issues because it's not simply, I don't think, about capturing land value. It touches the nerve of many political issues to do with enjoyment of one's own property, what the limits should be on the development of one's own property. But it also captures I think, the ongoing political, I'll call it a divide, but certainly the emotive issues that you get in an election between those who quite rightly want to preserve the nature of the island and keep the island green, and to not have overdevelopment. And I know that many a politician or potential politician would have stood on the basis of opposing inappropriate development in their parish or constituency. And of course, what's not to like about that? And nobody wants inappropriate development in their constituencies. But at the same time, there's a political reality where there is a housing shortage. And we'll be talking about that in a few weeks' time. We're not going to talk now about maybe the redistribution of housing and the fact that some people own, in some cases, many hundreds of properties, whilst others have none. But there is definitely a tension there. And so I think today we're probably going to establish a consensus that it is right that there should be some kind of capture of the uplift when a field is, let's call it rezoned. I heard the comments of the Constable of Trinity with his planning hat on. But that's the reality, isn't it? So a field can go from being worth relatively little overnight as an agricultural plot. Financially, we're talking about, because of course there's an enormous amount of value in having a field which isn't developed, but not necessarily financial, to being worth many times more overnight. And it's been suggested that that is unfair. Now, it's interesting that we take that almost as an axiomatic truth, because we don't necessarily say the same about a painting. So if you buy a painting which is not popular one day and then in 20 years' time, for whatever reason, because the subject matter of that painting becomes of particular interest or the artist becomes particularly well-known and collectible, that painting could go up in value by 1,000 times overnight. And I suppose that's the difference between a capital gain on the one hand, which perhaps goes into the area that Deputy Morell was talking about. And I noticed he put his light on, so I'm happy to give way.
Thank you, sir. It was just to clarify, would the Deputy clarify that when a painting becomes more popular, it's not because it's been ordained by the government or the Parliament. It's just something that happens in society rather than parliamentary ordaining.
I mean, I'm not sure that's that sounds like a second speech, but I'm willing to entertain that notion, even though we're getting it somewhat esoteric here in the tangent that we're going off on. It could well be that a government decision does increase the value of a painting. For example, if a particular subject were to become the chief minister and they were painted when they were just a wee whippersnapper and then they become Jersey's most famous ever chief minister upon their death, that painting might be worth many thousands of pounds. One could envisage such a situation. Of course, it could well be the opposite. You could find that a painting of somebody is devalued over time. So it can work both ways. But the point I'm making here is that there is a sensible thing to do, and I think Deputy Morell hits the nail on the head to a certain extent, and this is where other countries do it correctly. For example, France, I don't know the exact time period, but they actually have a period of time to stop you flipping a property. So, and this is especially the case historically when we look at the Jersey situation, where somebody might have bought a house using a state's loan, or they might have benefited from a first-time buyer property, and then they've sold that on for a relatively substantial amount of profit. You could make the argument, of course, then they then need to buy another house, so they're not necessarily any better off. But there is that. And of course, we've heard the same thing said about electric bikes and electric vehicles, where they could be sold on. So the sensible thing to do would be to have a capital gains tax, so you only actually capture the value of the uplift at the point where that profit is made, and it doesn't necessarily matter whether it relates to a field or to something else. But I think there are serious issues in Jersey as a financial centre about having a flat capital gains tax. So what we're doing here is identifying an issue which is fundamental about housing, the need for housing on the one part, versus the desire to protect Jersey's countryside, and also to stop people making maybe what some would call obscene profits from arbitrary state decisions, which would go in their favour. Now, the concern I've got, and we've discussed this within ourselves, is that in an ideal world, we wouldn't have had these amendments, because I think we could have done a lot more with this, and I understand why the amendments have been accepted, it's important that we get something tangible through today which the Assembly can adopt. My concern is that in voting for Part B, we have a 2-year period, which I think is too long for a start, and I would emphasise to ministers, the Council of Ministers who are bringing this back, that the 31st of March deadline, 2025, is an absolute deadline. It's not a target. And if they can bring that legislation in forward, a proper mechanism which does the job, they are able to do that much quicker if they want to. And my concern is that there's going to be a 2-year window where we're going to see people putting in lots of planning applications for rezoning in order to miss that window where they don't get taxed effectively. Let's call it a tax, even though it may not be. And that could be seen as either desirable or undesirable, depending on how we do it. Now, the counter-argument might be that there's already, without any charges in place, there's an issue getting people to put applications in for rezoning. The Housing Minister might have a particular view on it ministerially. He may have different private views as a citizen of Jersey. But presumably the Housing Minister wants to see lots of housing come forward as soon as possible, good quality housing being built all over the island for families to be housed so that they can either own or rent affordably in the island. I think that's something we would all aspire to, notwithstanding the usual balance between overdevelopment and protection of the countryside that needs to be made. So it could be seen that actually this Part B is a positive, because we would like a rush to happen in the next 2 years. We want lots of people, as I might say, slightly unparliamentary, to bang in planning applications left, right and centre, so that we can decide which greenfields we're going to rezone where and start getting these houses built in the next 2 or 3 years. And if that's the case, I'm very concerned about that. But I'm also concerned about the fact that actually this is a mechanism in the next 2 years for people to avoid paying the future tax. So on the one hand, you've got arguments about not being retrospective, but I'm concerned that there's going to be a lot of movement in the next 2 years for people who own greenfields to develop them so that they can make the profit without being taxed on it or being charged for that. And this is one of the unintended consequences of having such a long period in between the debate today and the period at the point at which this legislation would come into force. The last point I want to make is that this has been attempted before. So there was an attempt, I think it was Deputy Noel, who was the Infrastructure Minister at the time, attempted to bring in a land transaction charge, so effectively what we're doing today. And although many in the Assembly supported the principle of it, what we were presented with was a complete dog's dinner, because it sought to apply a charge to the land in terms of area that was being rezoned, not in terms of the uplift in value, which is, I think most people will understand, is completely nonsensical. You could have a large field where you're only building a couple of houses on it, because that's all you're allowed to, which won't go up that much in value, or you can have a relatively small field which is crammed full of housing, which would have done a lot of benefit for the profits, but wouldn't have been charged very much. So I think it's fundamental that whatever the uplift is, and whatever that charging mechanism is not just fair, but I would say proportional, and that we understand what it is we're trying to do with that charge. Is the charge a disincentive in one sense to stop people overdeveloping the countryside and not putting too many applications in for greenfields? Or is it simply some higher, lofty ideal of fairness about what the pound of flesh is that the government should claw back from the developer and the landowner? And I think that's going to be very difficult. So I understand why the word fair has been put in there, because we've put the word fair into previous government plans. It gives us a lot of scope for arguing about what fair policies are and what aren't. But similarly, on the other hand, it gives the Council of Ministers a massive amount of room to disagree with each other about what constitutes a fair mechanism for capturing land value. So I think, by all means, this is potentially a very good step today, and I commend Deputy Kovacs for bringing this forward. But I think the devil will be in the detail, and if the Council of Ministers, in their current form, can agree on anything, then I think this is going to be quite challenging for them.
Thank you, Deputy. Deputy Howell.
Thank you, sir. I too wish to commend what the Constable of St Peter has said, and I think we shouldn't be voting for anything retrospectively because I don't believe that would be fair. But I'm also finding it, although I agree with the principle that perhaps some money should be paid to the government, I'm not convinced that we have enough detail in any of this at the moment. And I am not happy. This is going to be the law, and we're not sure what we're voting on. We don't know what a fair charging mechanism is. We just don't know the details, sir. And I really would rather we weren't voting on this today and that we take it to scrutiny and we all discuss it further before anything comes in. Thank you, sir.
Yes, Deputy Rob Ward.
Thank you, sir. I want to speak to address what was just said and a couple of other things. So this, I would like to start by congratulating Deputy Kovacs on working so well on this and working so well with the Council of Ministers. She's certainly better at it than me. And I commend that patience and that tolerance in somebody. And I am learning all the time from my new colleagues. If we look at Part A, it does say a fair charge. The change made by the Council of Ministers was a fair charging mechanism. And I take on board the point made by Deputy Morell, sir, in terms of significant. But again, that is it within the gift of the Council of Ministers or those that are developing the legislation that will come back from this to define what that is. So it's still there for the point. And to Deputy Howe, that is the point of this. This is the beginning point, and then the rest comes back to us, and that's when the detail comes in. That's to some extent the way this has to work in order to make any change. So I hope that the Deputy is listening to that explanation of where we are. That's really quite an important thing. In terms of the timeline, I'm concerned that there's a 2-year timeline. And this brings me to Part 3, and I hope I can convince Deputy of St Peter, Deputy Howe, and Deputy Scott after the email we just received. Actually, Part C, I believe, is the most important part of this proposition. And it's the most important part because what it does is it future-proofs these changes so that we don't get a rush, so we don't get a chaotic move to say, well, we'll rezone land as quickly as possible to avoid any form of charge. If you don't do this, if there's any delay, we could have a really chaotic and really quite a poor system and bad decisions being made. What this says is that there are charges that will be being introduced, be prepared for them. And that goes with the principle behind that, which was a principle that was brought by the Council of Ministers. And it strikes me as strange that there would be any opposition to Part C when the principle brought by the Council of Ministers is that A and B will be a fair charging system over significant increases, and there's a time scale to give it time to develop. Now that was accepted by Deputy Kovacs in good faith, and I hope that can be returned in terms of Part C, because otherwise what we're creating is a 2-year void in what we're going to do, and I can see the whole thing falling apart because of that. And I really think that it is such an essential thing. We are a small island. There is a limited amount of land. A lot of money is being made of that. And we do need to have some sort of charging mechanism in the future. I personally would prefer a capital gains tax, but it would be unlikely to have any say over the way the charging system is. So I really would encourage members to look at Part C positively rather than negatively. I don't see it as retrospective, more as future-proofed, as a mechanism for, if you like, a safety valve for the change that might be made, because I think that's a really important point to have. And so I urge members to accept all 3 parts of this in this spirit of the fact that the amendments were accepted, a lot of discussion. And I think we all know that Deputy Kovacs works incredibly hard on the propositions he brings forward. So I think that needs some credit as well, sir. So I just encourage members to vote for all 3 parts. Thank you, sir.
Thank you, Deputy. Dr. Merrill, have you got a point of order?
No, it was to ask the Solicitor General a question, sir. Am I able to do that?
Yes, yes, I thought you might have a question for him.
Thank you, sir.
Yes.
It was just with regard to Part C, if I may use. It was just from a legal perspective, if we were to adopt Part C, is Part C legally are we capable of legally capturing the gap between now and the date the legislation comes in within the legislation? I just don't know whether that is legally possible or not.
Yes, it's legally possible. The position with retrospective tax provisions, at least as far as the European jurisprudence is concerned, is this. They may be compliant with Article 1, Protocol 1 of the Convention on Human Rights. They may not be. It largely depends on the detail of the provision. And of course, to that extent, there is no detailed provision before this Assembly today. There is simply a request in the proposition that the Minister goes away and works up a detailed provision. So to an extent, debate at this point is somewhat sterile. The debate will have meaning when there is, if there is, a retrospective provision that's laid before the states for it to debate and consider whether it wishes to adopt it in due course. But there's nothing entirely there's nothing remotely objectionable about C in its present form.
Thank you, sir, and I thank the Solicitor General.
Thank you. Deputy Ayer.
Thank you, sir. Firstly, I'd like to thank Deputy Kovacs for her engagement with the Minister for the Environment, the Constable of St Peters and myself in discussing the amendments. It was very productive and I hope she thought so as well. I'd also like to thank her for accepting taking it in parts as A, B and C, because I know that a number of members are against particular parts of the proposition. She did mention in her opening speech that she was a bit disappointed about Part B being changed, the timeline, and Deputy Tadeu and Deputy Ward also addressed that, so I'll just have a few comments about the reasoning for that. Less than 12 months is not sufficient time to develop a new charging mechanism and implement it. A considerable amount of work is required to support the introduction of any new charge. These include, among other things, an assessment of the viability of introducing a charging mechanism on the development industry. It will also require public consultation, which is necessary for a new tax or levy. There is also likely to be a need to develop new legislation to support and enable the introduction of a new charging mechanism. There is no off-the-shelf package for a new levy or tax in existence, nor is there a pre-prepared option waiting to be implemented. Legislating for a new charge without undertaking consultation, an impact assessment, or ensuring we have the systems and processes set up to administer a charge is likely to have unintended consequences and adverse impacts on the housing market. That brings us to Part C of the proposition, which refers to the application of a charging mechanism on a retrospective basis, as the proposition proposes to apply any uplift in land value from the date of lodging of the proposition rather than from the date the law is enacted. I do not believe that this is an acceptable course of action. We as an Assembly should not be seen to be implementing retrospective charges, which would almost certainly lead to litigation in some instances. This would not be a pragmatic way forward, and I would ask all members to vote against it. In the Deputy's report, it states that the Government of Jersey has to positively intervene to profit from land value increases. So I presume that the Deputy will also be considering bringing forward the introduction of capital gains tax, as mentioned by Deputy Tadeu, as a form of positive intervention. This may be the start of a journey down the slippery slope to permanent reputational damage to our tax structure, and it should be avoided. The report also states that roughly £100 billion could have been collected by implementation of such a policy. This figure is clearly not achievable, even applying the proposed 50% tax on uplift, which would be punitive in the extreme. And one can only imagine the headlines in the business sections of all the national newspapers declaring that Jersey was moving to a 50% tax rate. This figure was not incorporated within the proposition itself, but it is clear that it is the target that the Deputy wishes to achieve. The report also implies that there will be no detrimental effect to the ambitious building projects which are due to be constructed in the future. This may not be the case if such a levy or charge is too extreme. Some landowners may decline to sell their fields rather than pay exorbitant tax, thus leading to an extension of our housing shortage and thus an increase in house prices, which will be to the detriment of all prospective buyers. As somebody who stood on a platform of no new taxes, I will find it difficult to support this proposition, even after the amendments have been incorporated into it. Thank you, sir.
Thank you, Deputy. Does any of the members wish to speak on this proposition? Deputy Mezek.
Thank you, sir. A few speakers have taken issue with Part C to this proposition, including Deputy Ayer, and they've used the word retrospective several times. So I've just looked up the technical definition of the word retrospective, which is looking back on or dealing with past events or situations. This proposition doesn't look at any past events or situations. It looks exclusively to events in the future from this moment in time. So we're not debating imposing some form of charge or tax or levy on people who have already undertaken actions and have planned their transactions and business affairs in a particular way and have contracted to that effect and have obligations resulting from that. We're only talking about people who may do so in the future from this moment in time. It would be the Assembly saying its intentions from today. Okay, the law won't be passed, but it'll come back to the Assembly and we have a subsequent debate on it at that point. But from today, we send that message out to anyone who might be in a situation where the other provisions of this proposition could have an impact on their affairs, know what the case will be. They know the States Assembly has already resolved that that mechanism is to apply to me. Therefore, I need to bear in mind that it applies to me whenever I conduct my affairs and contract on any kind of seeking planning permission or seeking rezoning or whatever. So this idea that there's any kind of unfairness or unreasonableness in Part C applying exclusively to things that are going to happen in the future seems to me to be the unreasonable position. We've had from the Solicitor General confirmation that kind of arrangement is potentially acceptable. Obviously, it depends on the precise terms of it, which this Assembly will get to look at and decide on later anyway, but that it is possible. And so I don't think it's right or fair to use the kind of language that has been used by previous speakers on Part C. It may well be retrospective at the point we debate the law, but it's not retrospective today. And if we do vote in support of Part C, everybody out there in the island will know what's what. They'll know what the case will be because the Assembly, the democratic decision-making body of the island, will have resolved on it and sent that message out to those people. So I don't see how there can possibly be any cause for complaints in that regard. They'll know what the rules are, they can act accordingly and get on with things as they see fit on that basis. So I think that point of criticism is unfair, and I hope members will consider supporting Part C, because if you support the other parts to it, and you agree in principle that you want to have a fair charging mechanism, and that's what the word is in there, it's fair. None of us are going to disagree with trying to do something that's fair. If you agree that it's fair, why would you not want it to apply to those actions that may take place from this moment until the law comes into force? You would be saying you're happy for more transactions to occur that take advantage of the lack of implementation of a fair charging mechanism in the meantime, and that is to see the public ultimately lose out from the revenue that could raise, and the benefit that the wider public could see because of that, and also, of course, risks that people try to expedite their affairs specifically to avoid having to apply by the mechanism when it's eventually introduced, and therefore we lose out on more. So Part C is a sensible safeguarding measure to ensure that nobody's treated unfairly and that the public gets the maximum benefit in the meantime without losing out because of that advance notice being given. It seems that the other parts are uncontroversial, and it sounds like most members are in support of the principle of doing this. It's been a long time coming, and there's been debates on this in the past, but if we can get this over the line this time, come back and debate that the legislation to enact this when it comes forward, then we'll be getting a lot of benefit for our constituents. And it strikes me as bizarre to not want to maximise that on an entirely fair basis that focuses purely on the future and not the past.
Thank you, Deputy. Deputy Farnham.
Thank you, sir. And may I, sir, just for the record state that my family do have landholding in St Wands, sir, but there is certainly no intention to apply for any form of planning permission on them. I think referring to something the Solicitor General said, today we are really very much discussing the principle, and the devil, of course, will be in the detail, so when that comes back, if this is approved, when the legislation comes to the Assembly for approval.
Pause a moment. I've got a point of order, Deputy Howell.
Yes, I just wonder if you may consider Standing Order 85, sir.
Proposal to move the next item. Are you prepared to wait until the end of this speech from Deputy Farnham? Yes. Deputy Farnham, please continue.
Thank you, sir. So whatever, whilst we agree the principle today, and there's some quite specific requests for the government in the principles, of course, when the legislation comes back, it could not totally abide with these principles, which would be fine, because the Assembly has a right to debate that separately. But I would warn the government, and I'm sure they realise that the legislation would have to be broadly based on what we're agreeing today. So it is important we think carefully about the 3 paragraphs. And I think from the members I've been speaking to, what I've been hearing in the debate, the majority of members are in favour of the principle of this. And I think in paragraph A, I think there just needs to be some clarity. And I don't think it's clear, for example. I think it's slightly ambiguous when it refers to a significant uplift in the value of land arising from when the land is rezoned or from when planning permission has been granted. So there needs to be more detail around that. So I'm likely to be supporting this proposition in its entirety. I might not support paragraph C, but I'll think about that when we get to the vote, because I do think to actually tie something down to start from effectively, if this proposition is proposed without knowing what we're going to end up with is probably, whilst I think I understand the principle and the reason for wanting to do that, I'm not sure it's politically wise to do that. So until we know what we end up with, what the law would look like, and what scale of land levies we end up with. So thank you, sir. But I just wanted to reserve, if I may, the ability, sir, to, when the legislation comes back, if this is approved, to vote on that legislation as it's presented, which might not be in line with some of what we're agreeing today, sir. Thank you.
Thank you, Deputy. Deputy Howell, are you proposing making a proposition under Standing Order 85?
Yes, sir.
Yes. Well, this is a proposal to move to the next item, which would bring this debate to an end for this session. The presiding officer should immediately put the proposal to the vote without a debate, as long as they're satisfied that there's no infringement of the rights of minority and no abuse of procedure. And the rights of minority is traditionally regarded as the presiding officer being sure that at least 10 people have spoken in the debate. And I think 12 have, although 2 are listed to speak. Deputy Gorst, you put your light on, but there's no debate on this proposition. Is it a point of order?
Yeah, I'm not asking for a debate, so I'm asking for you to remind the Assembly what the process is for the proposition should a move to the next item be approved. Thank you.
The proposition will return when the Assembly next meets in 3 weeks' time, if that's the wish of the proposer. That's the effect of it.
So I do have a point of order as well, but...
Yes, of course, yes. Yes.
So it's, sorry if I missed it, but every time this happens, of course, there's 85.2, which the presiding officer gives consideration to as to whether it constitutes an infringement of the rights of the minority. And I don't know if you're able to rule on that at the moment, but it seems to me that I've never seen an instance of when it is an infringement of the rights of the minority. So could you comment on whether you consider this to be an infringement of the rights of the minority or not?
Well, the conventional approach, Deputy Tadier, adopted by successive presiding officers, is that it is regarded as an infringement of the rights of minority if less than 10 members have spoken before putting this to the vote. That's the traditional approach that's been taken.
So could I put something on record, because I think it's important for future reference, if not for now, is that I don't think that's the only thing that it means. It doesn't say, for example, that 10 members should have spoken. That's a different standing order. But the point I wanted to make is that the rights of the minority are important, because in a future scenario, and it could be hypothetical, you could have a bipartisan system where you have one party with 70% of the seats and another party with 30% of the seats, and every time the dominant party will invoke Article 85, effectively meaning that the minority, and we're all in the minority in fact, whether it's Reform Jersey or an individual backbencher, I think that's exactly what the right of the minority is, sir. And that for a majority to say that a minority simply can't have their proposition heard seems to me to be a fundamental undemocratic mechanism, which you might argue, sir, it is the very essence of 85 anyway. So I don't know if you can rule on it now, sir, but would you give that further consideration?
Well, I think the point you make is an entirely legitimate one. And I think that notwithstanding that rule, if the position was that none of those 10 members who had spoken had been from your party, then that would be an infringement of the rights of minority. And I've just noted that 4 members have spoken, but the point you make, I think, is a legitimate one and a valid one. Nonetheless, that's the proposition that's been made. Is it seconded?
Yes, sir.
It is seconded, and it will now be put to the vote without debate. And the proposal is to move to the next item. And I invite members to return to their seats, and I invite the greffier to open the voting. All members, both present and remote, have the opportunity of casting their votes. Then ask the greffier to close the voting. I announce that the proposition has been rejected. 8 votes for.
So may we have the eight?
32 votes contra.
Sorry, so may we have the eight?
Yes.
Those members voting for, the Connétable St Bellard, Deputies Ayer, Scott, Howell, Berry, Barbara Ward, Rose Binet, and the Connétable St One.
So we're down to the debate. The next speaker is the Connétable of St Clement.
Sir, I'll be as quick as I can. But I do need to point something out. Broadly speaking, I'm in favour of the proposition. I think it's a good one. Mountains of money are being made, and we want some of it. That's clear. But paragraph 3 is a problem, because I think we're being slightly naive. What will happen is, with developers and landowners not knowing what the percentage contribution might be to this new tax, all negotiations will be frozen from this point. And I just need to point that out. They will be in negotiations right now, and whatever those negotiations are, the minute word gets out from this assembly that we are talking about a tax which might be anything from 10 to 50%, those negotiations will stall because they will not know and will not be able to calculate how much money they're going to have to fork out in the tax. So I'm just pointing that out because I think everybody needs to know that paragraph C is a potential problem. Thanks very much, sir.
Deputy Renouf.
Thank you, sir. I want to begin by thanking Deputy Kovacs for engaging with ministers over the content of P14 and for accepting the amendments we have brought forward despite her slight misgivings, and for taking the proposition in parts, which I think is very important because it gives the option for people to agree with some parts of this proposition and not with all of them. And this means we can have a cleaner, simpler debate, as indeed we have, where the main issue at stake, at least from my point of view, is part C of the proposition, because that's the aspect over which ministers still disagree with the deputy. So whenever this subject comes up, the media take great delight in quoting back to me a statement I made in a column that I wrote for the JEP in 2021, before I stood for election, stating that I supported a tax on the increase in land value on rezoning because it represented a, quote, colossal unearned income, and mentioning 20% as a potential figure for that tax. Gosh, I must say I was a bit of a firebrand in my youth. However, I am pleased to say that I do still support the principle of a tax on the increase in land value, although now with perhaps a greater understanding of the practical difficulties and complexities that such a policy might bring. Let me dwell on the principle, though, behind this proposition for a moment, if I may. The proposed charge is on the increase in value of the land due to rezoning. It's not just that this is unearned gain that I would like to point out. The point I would make concerns the source of the value in land that is rezoned. The value of land in Jersey today comes from the sum total of private and public investment over time. A very significant part of that investment is the public investment in the legal system, roads, ports, healthcare, sewage treatment, education, and so on. Without these building blocks of society, paid for by taxpayers over the decades, the value of land would be much lower, as it is in countries where these investments in social and physical infrastructure have not been made, and where land is indeed worth much less. I can give a simple demonstration of the principle from my own experience. When I moved from living in London to living in Cookham, outside London, I saw house prices in our area increase when the Crossrail development got underway, speeding up links to central London. Nothing to do with me. That was a taxpayer-funded development that ended up adding to the value of property in Cookham and to the land on which it was built. 100 years ago, a famous politician of the day made the same point in rather more colourful terms. Roads are made, streets are made, services are improved, electric light turns night into day, water is brought from reservoirs 100 miles off in the mountains, and all the while the landlord sits still. That's from a speech by a well-known left-winger, Winston Churchill. So the value of land for building is derived to a very significant degree from social investment, built up over time, provided for by the state, and based on guarantees of property rights and the rule of law that are also secured by government. Therefore, I believe it is justifiable to try and capture some of the increase in the value of that land for society, to contribute to the wider community investment from which the value of the land is in part derived. The main argument used against the idea of putting some kind of tax or levy on the increase in land value that comes with rezoning is that it will increase the cost of housing. Not so. I agree with Deputy Kovacs on this. The price of housing is not set by a developer of any one development. It is set by the market. In fact, it's a curiosity of the housing market that second-hand property is worth as much, if not more, than new property, which means that any new development is competing for buyers with all other homes in the market. A developer or landowner may try and recoup the money lost to tax, but they will find they cannot increase the price of the homes they sell beyond what the market has already set. If I may quote from an excellent piece by Philip Sivray in the Bailiwick Express last week, when assessing land values, developers work backwards to calculate residual land value. In simple terms, they look at the final sale price of the houses to be built on the site, deduct cost of building, deduct expected tax and other economic costs, deduct a rate of profit, and what is left is the price they're willing to pay for the price of the land. End quote. In other words, the effect of the tax will be to suppress the value of the land, not increase the cost of housing. We can safely reject the argument that a tax or charge would increase the cost of housing. Mr. Sivray does, however, point out another potential problem. It is difficult to calculate the tax, and because there are uncertainties about how it will be levied and at what level, it may lead to landowners sitting tight rather than bringing forward land for development. I draw two conclusions from this. First, it is vital that we get the tax or charge right. It has to be clear, it has to be easily understood, and absolutely crucially, it has to be at a level that doesn't deter landowners from bringing forward land for development, as many speakers have pointed out may happen. The second conclusion is that any proposed charge needs to have a lot of support. If it doesn't, then it will be susceptible to landowners or developers seeking to undermine it. Put bluntly, there needs to be a credible commitment to maintain the tax indefinitely if it is to have a chance of success. All this needs consultation and a lot of work. That is why our amendment extends the deadline to bring forward proposals to the end of March 2025. I cannot emphasise enough, as Deputy Iyer said, there is no off-the-shelf package waiting to come into existence. We do not have examples from around the world that just can be lifted off and put into Jersey. We don't have pre-worked up ideas of how this would work in practice. It will take time. The UK has been unsuccessful in introducing many different types of charging mechanism over many years to capture the uplift in land value due to grants of planning permission or rezoning. Jersey does not want to follow in these footsteps by introducing the wrong type of charge. Crucially, whatever proposals we bring forward must have regard to our other aims, which are to ensure that sufficient land is brought forward for housing, both now and in the future. And I would further add to Deputy Tadia's point that there is, in practice, little chance of a field being rezoned outside of an island plan. It can be done, but it would have to be done within the framework of the Bridging Island Plan and the spatial policies therein. One further point to emphasise is the complexities. One further point emphasises the complexities. The Bridging Island Plan includes, as has been noted by Deputy Morell, proposals for a land development levy that would be paid into a new Sustainable Communities Fund. It was envisaged that this would apply to all developments over a certain size, whether or not they involved rezoning, albeit with some exceptions. As I say, this is the issue picked up by Deputy Morell. Clearly, work will need to be done to see if a rezoning charge would replace the land development levy, or whether it could be integrated into it in some way. Either way, these are complex issues. There's a lot to think about, which is why the additional time is so vital. And I would also say, as has already been pointed out, that of course, whatever our course of action ends up being proposed, it will come back to this Assembly, where it will be subject to scrutiny and the possibility of amendment. Now, let me turn to Part C of the proposition. I'm afraid we cannot support C, and I would agree with comments from the Constable of St. Peter and others. It argues for a tax to be applied not from the moment when it becomes law, but from the moment this Assembly indicated its desire to have a tax. It would, therefore, apply retrospectively. Quite apart from the principle of retrospective taxation, which I do not support, there were strong practical reasons why this would be a very poor measure. And in this I must disagree with Deputy Mezek. It will be retrospective. Part C would explicitly capture the increase in value in any fields that were rezoned in the past for the Bridging Islands plan, which are sold from this day forward. It would not capture the increase in value of fields that were rezoned in the Bridging Island plan, but which have already been sold. It would capture, however, if Part C were approved, any increase in value that occurred to fields that had been rezoned in that past Bridging Island plan. That is the sense in which it is retrospective. We need landowners to bring forward the existing rezoned fields for development. Saying now that we are considering developing some kind of charge or tax, the exact nature and extent of which remains uncertain, is, as Deputy Troy has pointed out, Constable Troy has pointed out, I beg your pardon, is as good as telling those landowners to sit tight. Don't bring forward any land for development until you know what kind of tax you're going to be hit with. We're dealing with simple economics. Why would you commit to anything without knowing the costs you might incur? Now, I know Deputy Kovacs may protest that the last two words of Part C say we should only do this if possible. I'm afraid I don't think that's a good enough get-out clause. Part C of the proposition mandates us to go away and look at the possibility. Whilst that happens, you can be sure that most landowners and developers will pause their plans. We're just adding extra political risk and uncertainty into the equation, which might require plans to be modified by developers depending on what happens. We cannot afford to have that kind of gratuitous spanner thrown in the works of the urgent need to build new homes. I do understand the emotional desire to try and capture some of the uplift value of fields that have already been rezoned but not yet sold. But it is not practical or wise. And apart from the objection already noted, I would make one other point, which has not yet been made. Because we should also appreciate that it is not the case that just because there is no tax, the landowner is making no contribution to social good out of the rezoning in the Bridging Island plan. Government is already effectively restricting the increase in land value by determining that the rezoned fields will be for affordable housing. What's more, a combination of supplementary planning guidance, the development briefs for each site, and potential planning obligation agreements are all ways in which society can and will extract value, some value, from that land that has been rezoned. It would not be fair to add in a retrospective tax to that mix as well, long after the rezoning took place. And it would, in all likelihood, be heavily self-defeating. The land would not come forward for development, houses would not be built, and the tax would not raise any money. We need to let go of that idea and reject Part C. In summary, sir, I am pleased to support Parts A and B of this proposition as amended. They set out a worthy ambition, but one which will require a lot of work to achieve. But I cannot support Part C, and I urge rejection of that part. Thank you.
Thank you, Deputy. Deputy Coles.
Thank you, sir. One of my main parts with Part B, with the expansion of the date, is it's by the 31st of March 2025. And I appreciate everything that the ministers have been saying regarding setting up the right mechanism to capture this. However, that is the latest deadline, and I would hope and urge that the ministers would try and have something brought forward sooner than this date. So as soon as possible would be greatly appreciated with Part B. I think it's worth reminding everybody within the Assembly how land is selected for the island plan. And the fact that there is an assessment made and the government approaches landowners to see whether they are willing to sell their land or, to repurpose their land for rezoning for housing, should it meet the criteria that the government set out. But it also asks landowners to volunteer their land for this in the first instance as well. So at no point is anybody having a gun held to their head saying that their land has to be rezoned. They can opt out. They can say they are not prepared for it to be rezoned. However, as I'm aware that one member of this Assembly is constantly trying to buy agricultural land so he can use it for his own interests and to actually carry on agriculture on this island, but is frequently rejected even though he puts in his mind, justifiable offers, but unfortunately the landowner does not always agree to that as well. There is also the mechanisms within planning to slow down development at this point. We are, as a member of the Planning Committee, constantly faced with developers wanting to develop pieces of land which are agricultural in mind, and they have to prove the redundancy of agricultural purposes. And this is something that comes in with this term of significant, because we are continuously faced with an ambiguity around the term of significant. We look at some designs and we're told that this forms a significant reduction, even though that's only 20% reduction is that significant. But then we are told that, you know, this provides a significant number of homes, which might only fracture a single percentage of homes in a development. So significant is a very ambiguous task. But still, it is open to interpretation, and I hope that even a small increase, which is done almost from nothing other than the government saying we would like this land as it to become part of our built-up area, that actually shows a significant intent to provide something. So a significant here, a significant there. So we have to then consider what Part C, and Part C is very important because this means that anybody could be rushing out now to try and request that, put their planning application in now, so they can try and develop land before a levy is put in front. But actually this could be a very large development, and as Deputy Kovacs points out within her report, the field in St John's, which went from a greenfield value of around £70,000 to a brownfield value of £3.5 million, that's huge, that's astronomical. And yet that is something the government has to approve. It is a windfall from doing absolutely nothing. But that landowner was under no obligation in which to do this. They chose to do this. So why shouldn't the government be introducing a charge, a tax, or whatever you'd like, a levy, whatever you'd like to call it, on this person who has gained astronomical value from just agreeing to repurpose their land? So I think we should be considering when that line has to be drawn in the sand and say, actually, no, this has been implemented. This body, and it's saying, if we vote on it today, that from today, that if you are going to repurpose your land, you will be subject to a levy. I understand the worry about whether then a developer will choose to buy it, but however, the developer might not be the one paying the tax. It might be the person who's actually sold the land to the developer. The developer is still only going to pay what the developer chooses to pay for the land. If the developer gets told, actually, it's going to cost you, instead of £3.5 million, it's going to cost you £4 million, so I can recover the difference in my tax, well, then the developer will go, well, actually, the maths doesn't work. I'm sorry, I'm not going to buy your land. And so, therefore, the landowner doesn't get to sell and has to wait a little bit further on. Or the developer says, okay, I can afford your £4 million, and actually, the landowner is actually going to have to pay more tax than he was going to pay before because the levy hasn't been introduced. I want to address Deputy Ayer's comment, though, about the 50% tax. Obviously, there is nothing in the proposition that says that it's going to be 50%, but actually that the fair charging mechanism is brought in. and worrying about the headline tax. One of my colleagues, Deputy Feltham, mentioned that how many developers take their tax advice from the newspaper headlines, or actually whether it be more about what's actually brought in. But I sort of make this point in the sense that if the ministers come back with a levy that is less than what we consider our baseline of tax of 20%, you can be sure that there will be an amendment coming from me to introduce it to at least a minimum of 20%. And hopefully we can structure something a bit better and gain something for the island of Jersey as we move its green space. But I'll leave my comments there. Thank you very much.
Thank you, Deputy. Does any other member to speak on this? Deputy Gorst.
Thank you, sir. And I just wanted to add, hopefully, a bit of colour to some of the things that have been said. It is fair to say that an agreement in principle today in regard to this proposal is the easy bit, because we've had several agreements in principle previously to seek to capture the uplift in value when land has been rezoned for development. So this is the easy bit, and this is why the Minister, and I'm grateful to my two assistant ministers as well for the conversations that they've had, why they've sought to amend not only the mechanism but also the timescale, because it will take time. I'm not absolutely convinced that the value of land doesn't filter and play a large part in the overall price of housing. I know that the Minister quoted an eminent lawyer in an article in a publication. Perhaps, so you forgive me for saying this, perhaps it's like accountants when they're talking about numbers. Dependent on the client they're representing, the argument they make can be sometimes the opposite one. And I have known lawyers very strongly make the case that levies such as this would go directly onto the top line of the cost of housing. So that consultation, that careful approach really does need to be taken, because on previous occasions when this has tried to be done, and I look to my left here, that there have been some very strong arguments which members have accepted, that developers would simply land bank and see out what was then the government and wait for the next one to come in and to amend it so that the supply of housing wasn't interrupted. Developers, we know right now, are land banking and have done across the island for a number of years. And we know that landowners do hold on to land even if it is rezoned until they can get what they consider to be a reasonable price. So it's okay for us to come into this assembly and naively hope for the best. The reality of economic conditions and the way that developers work and the way that landowners might seek to operate has to mesh with the aims of this assembly. And that's why it will take some time. I know that I look across to see the Constable of St Clement. There were very strong representations from hotel owners that such a levy would undermine the value of their hotels and therefore undermine the leverage that they could get and mean that they would have to withdraw from the hospitality industry. So we need to go into this in-principle decision today with our eyes open, and I see nodding, I see shaking of heads. I am supporting parts A and B. I'll come on to C in a minute. But I am doing so with my eyes absolutely open, and I'm slightly concerned to hear the immediate speaker in front of me saying that if what the government brings forward doesn't meet his threshold of percentage, then he'll come and seek to amend it. That is absolutely his prerogative in the Assembly, but it does slightly worry me that after the work that the Minister will undertake rightly, we might then see some amendment which would scupper any such levy anyway. When it comes to Part C, if the Assembly vote for Part C, as the Solicitor General said to us, there's nothing ultra vires in the way that Part C is framed. And the reason is because it doesn't say how it's going to deliver that retrospectivity or whether quite it will. And what that will mean is that those developers, land banking, those landowners owning land will simply wait. Why wouldn't they wait? Because if they don't wait, they will be liable to an unknown risk and an unknown liability. And therefore they don't know what application to put in, how many houses to go for, what will be the best mix of housing in order to mitigate the levy. That's how developers work. And that's exactly what they would do. And that I think for all the reasons that members have said that we shouldn't support C, is not that it's ultra vires, because it's not, but the potential to put a simple block on sites coming forward is not something that we should be doing when part of the problem we face is a crisis of supply. And we've got to get to grips with the crisis of supply of housing. So I will be supporting the Deputy in parts A and B. I recognise that this decision is really a relatively straightforward decision. The difficult decisions will be down the line. Thank you, sir.
Thank you, Deputy. Does any other member to speak on this proposition? Yes, Deputy Alex Curtis.
Thank you, sir. And I'm glad to follow the Treasury Minister's comments, a lot of which I agree with, including that of the taxing and the increased value of land. I don't think necessarily directly translates into more affordable housing, and I think there are other ways to approach that. What I did want to touch on briefly was the second part of Part A, which is the increase of land value by grant of planning permission and not rezoning. Now, I'm wary here because I might be sounded to be on the side of developers, which, given their reaction sometimes to me, is quite a shock, and I don't want to give them heart attacks. But I do want to briefly consider how often, under an island plan, the grant of planning permission significantly increases the value of that land. To take an example, let's think about a site within the built-up area with a single property but a large garden. Under the Bridging Island plan, that is the built-up area, allowed for development, encouraged for development for properties, so long as they are not overbearing, so long as they do not impact character of the landscape and similar policies. The value of that land was baked in at the Bridging Island plan, but for most sites in the built-up area, that value of the land was baked in the 2011 Island plan, in the 2002 Island plan. So a developer looking to buy a site within the built-up area is not significantly necessarily gaining value from the grant of planning permission. They are buying a site without planning permission, with the cost knowing the presumption of development will be permitted on that site will be granted. So if we take an example, let's say that plot is worth £3 million, a single house. Let's say it actually does qualify against policy GD5 for demolition and replacement of buildings, so that we have a clean site. That site is in presumption of development of housing, and they are right to buy that for the value of a site within the built-up area. That is a long-standing understanding of what that site might be worth, and many policies haven't changed too much. Now, say they are granted planning permission. The site will likely go up in value. Certainty increases value. You will know you can develop that site. But nonetheless, if that site clearly would have accorded with development within the built-up area, that site would be granted planning permission if it accorded. So the value of the land hasn't significantly increased. The value of the properties on the land and the total value of assets sitting on that land would increase, because you may go from 1 house to 4 houses to 5 houses. However, the value of the land hasn't. So the reason I raise this is these are the examples of the challenges that must be worked through the detailed process of defining this. The difference between the value of land, the difference between the value of property sitting on top of land, But there is a caveat to that will require the fair and balanced application of planning policies. If a house is approved in the green zone that doesn't comply with policies, well, someone who took a punt on that will have seen a great increase in the value of their land, but only actually through the misapplication of planning policy. So I would briefly caution members that when we review how to apply such a policy on planning applications, so long as the Bridging Island Plan and subsequent island plans are followed carefully, many sites will not see significant increase in the land itself. Development will create value, but not necessarily from the land itself. So the devil is in the detail, and I look forward to contributing to a detailed approach to this, and I will be supporting parts A and B.
Thank you, Deputy. Does any other wish to speak on this? Deputy Lewis.
Thank you, sir, and I'll try to be as brief as I can. Every time the Planning Department put the stamp of approval on an application, an increase in value occurs, or 99% of the time. And certainly in the past, as Deputy Gorse referred to, I have brought forward to this Assembly a community infrastructure levy which sought to gain a little bit of that increase in value back for government to use for community schemes. And to put it in a very nice terms, I got right royal beating up in this Assembly when I came forward with that proposal, but there we are, and that's democracy for you. But I support this proposition because in many ways it's seeking to do exactly what I tried to do all those years ago. The second thing I want to say, sir, that I agree with Deputy Gorse and others that it's a little bit naive to think that land value has no effect at all on the price of property. And I say that, sir, because I know people who have had fields rezoned and refuse to sell them. Absolutely point blank refuse to sell them for development because they don't need to. Anything we do which might affect the sale of plots will increase demand because we reduce supply, and it can have an indirect effect. Nevertheless, I'm going to support this proposition. But what I do want to end on, sir, is the word certainty, and others have used that word, and I worry greatly about Part C, and I'm going to explain why. It refers directly to Part A, which is a fair charging mechanism on land that is rezoned, and then the important bit, or from when planning permission has been granted. And I take that to mean not just on rezoning, on other pieces of applications which may be brought forward. And as other members have said, sir, if we pass Part C, everything will stop until such a time as the detail has been dragged out. And that will mean not only will plots not be sold, but not will fields be sold for development. I think that people may well look at A and that last sentence, this last part of the sentence where planning permission has been granted, to say, I'm not going to do this large development on my property, I'm not going to add value, I'm not going to significantly increase the value of my property by putting in a large application to change what I own, and I will wait to see what the tax is going to be, because only at that point will I know whether it's right for me to move forward or not. So I urge members to think really carefully of Part C. The unintended consequences will be that nothing will come forward for housing that we desperately need until the time that we have made that detail known to all and we can see exactly what's happening. Thank you, sir.
Thank you, Deputy. If no other wishes to speak, I call upon Deputy Kovacs to reply. Deputy Kovacs.
Thank you, sir. I want to thank everyone that has contributed to this debate. And all the opinions are valuable to be considered. I'm also a bit disappointed on the attempt to delay it even further to move to the next item. I don't think would have created any value for neither of us. In the same time, I value, as I said, the contributions from each member, and I think it adds value to the definition of fair, what Deputy Scott to consider to be ethical, and also what Deputy Tadier said to be proportional. On the mentions that were done by Deputy Scott on the Sustainable Community Fund and the differences on the environment and infrastructure departments, although the main respondent is the Minister for the Environment, as I discussed with them as well, I don't want this to be forgotten to explore all the avenues possible and find the best charging mechanism. On mentioning that because of the point C, the landowners might not bring this forward, again, the flexibility is in finding the best mechanism by the minister on how this can be addressed, and application, for the example, can be found a mechanism where application brought forward sooner could be charged less, and as well to give a level of certainty, even if the legislation will take longer, the information in principle of what kind of tax or levy would come, that information can be made public by the time where the legislation go to be drafted. So people would know in advance, which could be a few months or a year, so it would be less than the time frame given. Was much reference as well on the 50% tax mentioned in the text of my report. That was mentioned because also the report of the Deputy of St. Mary, which I quoted extensively for, was also mentioning it, but also to address the fact that what was publicly stated before, that the Sustainable Community Fund, which has 3% tax, could be possible to have this charging mechanism, is also not acceptable. So to show that it's a much, the 3% is a much different unrealistic figure, I would say, than what I'm expecting to see. And I think the conversation with ministers was quite going in the right direction on this, and I thank them for showing openness, finally, for communication and collaboration with Reform Jersey, and I hope this will continue. What Deputy Alex Curtis said about planning application, charging mechanism at the planning application point as well, it says the word "or" in it, and the minister has all the means to explore what's the best way of either or neither, and find what the charging mechanism will be put in place. And trying to keep it short, I'll address the rest of the concerns in general terms. For this, I want to make a few more references to previous related reports. Green Paper report R101 from 2011 by the then Treasury Minister mentions at page 10, with reference to fairness, windfall profits are those caused by factors outside the control of the landowners, such as buoyancy in the property market at the states agreeing that a piece of agricultural land may be used instead for residential housing. It can be argued that where the public has helped to create this profit, they should share in it. There is also a cost to the public in the form of the loss of the environmental benefits provided by undeveloped land. And at page 21, referencing the development gains, it says, using the same principles discussed above, there is an argument that the public should share in the benefit accruing the landowners from the uplift in the value of land, where that uplift comes about because of decisions of the states to approve the development of land. Most frequently, an uplift in value would be triggered by the planning minister granting an application for planning permission. It could also come about through the island plan process, whereby the states vote the particular parcels of green or brownfield land may be used instead for housing purposes. The land immediately becomes more valuable once the decision has been made, without the owner having done anything to cause it per se. A discussion of taxes on development gains must reflect the state's intention to ensure the supply of affordable housing for Jersey's population. Viewed in this light, the tax system offers one way of supporting development while also producing direct benefit to the public at large through increased tax revenues. Considerable work has been done on introducing a specific tax on development land in the past, Uxeria papers on land development tax shows, and it has been agreed that it would, in theory, be possible to levy a tax on this uplift in land values. On the report quoted in my opening speech, it was also highlighted, and I'm glad that the Minister for Environment also agrees, that the price of land does not drive the cost of housing. If it did, then it might be argued that the land value could affect the end price of housing. On the contrary, it's the end price which can be achieved, which determines the value of land. The end price reflects scarcity and the willingness to pay of enough people who are in the market for buying a house. This proposition is about finding a way to distribute a vast private unearned gain to the public good. Also, we could see from previous mentions, the community showed no opposition in principle to the tax, and or there was general public support to capture some of the increase in land value after planning permission has been granted. Referencing to such tax review, there were quite few mentions that much work has been carried out on it already, or that reviews of related tax systems have been started at some points. Then surely at least some of the work carried then can be found and used to continue on it. Despite claims that it was already being looked at, nothing happened. I hope that will change soon. The amendment from the Council of Ministers and States members also made the comparison with other jurisdictions. The big difference between previous attempts to raise such a tax or levy in the UK and elsewhere, cited in the report to the amendment, and the present situation in Jersey is clear. In those countries at those times, there was an ongoing plan for development of large swaths of the countryside into huge housing estates, new towns, out-of-town shopping malls, industrial estates, and so on. For this reason, it was necessary to continue to encourage farmers and landowners continually to plan for and to make their country estates available to builders. As far as I understand recent island plans, there are no such ambitions for most of Jersey's countryside in the foreseeable future, nor should there be. With reference to the point C, arguing on the legal aspects of what could be perceived as retrospective charging, I have been reliably advised that if the nature of such charge is in the public interest, which my report highlighted that it is, then it is acceptable. Also, although it might appear as being retrospective, it is not really in nature. It is not being applied in the past, but from the moment of the approval in principle, if this proposition part is to pass. This is something that has also been done before during COVID, so it could be possible. I have mentioned before the importance of this Part C still being in place in the light of accepting the extended deadline in the Council of Ministers amendment, as speculative transactions could occur in the meantime and also opportunities could be missed, like capturing revenue to be used for housing from any uplifts of the estimated 40 million referenced from the Appendix 1 of the existing Bridging Island Plan. By using the words "if possible" at the end of this paragraph C, it also gives the flexibility to explore if there's such possibility or not, and I hope this would make it acceptable to the states members. In the end, I want to quote again the relevant part of the Deputy of St. Mary report. On any uplift of 50 million, a modest tax of 50% would yield 25 million over a period of years, a sum not to be sniffed at. And at this rate of tax, the landowners would still receive an unearned windfall of 25 million. This windfall is entirely due to the government decision and government policy, and it is entirely appropriate that the enormous financial gain involved should come back, at least in part, to government. With that being said, I hope we can agree on this work to start soon, not to continue to deter and delay and create further uncertainty. Having highlighted the considerable public gain, if this proposal is passed, I now call for the appeal, and I will take the voting in parts A, B, and C.
So, Dr. Kovacs, do you want to have A and B and C separately, or A and B together and then C? It's better for you, your proposition.
A and B together and C.
A and B together and then C. So the first vote will be on paragraphs A and B of the proposition. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting.
So is this on Part A?
Part A and B. All members present in the chamber and joining remotely have the chance to cast their votes. I'll ask the greffier to close the voting. And I can announce that parts A and B have been adopted. 40 votes for, 2 abstentions and 1 vote contre.
Can I please have the abstention and contra?
Those members who abstained, the Connétable Grouville and Deputy Lehegara and Deputy Ayer voted contre.
now move to part C. And I invite the greffier to open the voting. All members present here in the chamber and remotely have had the chance to cast their votes. Then I ask the greffier to close the voting. I can announce that part C has been rejected. 10 votes for, 2 abstentions, and 31 votes contra. Next item is Jersey Homes Trust rent increase assistance scheme lodged by Deputy Southern. The main respondent is the Minister for Social Security. Deputy Southern has been marked excuse and has given the requisite notice to the greffier that he wishes, under Standing Order 68A5, for Deputy Mezek to propose the matter in his absence. I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to request the Minister for Social Security, in consultation with the Minister for Housing and Communities and as a matter of urgency, to establish a scheme for those tenants in relative low-income households affected by the Jersey Homes Trust rent increase of up to 9%, whereby rent increases would be subsidised in whole or in part for a period of up to 3 months.
Deputy Mezek.
Thank you, sir.
Thank you, sir. And can I just start by acknowledging Deputy Southern, who we know can't be here today. He has done all the work for this proposition and I get all the glory. I think that's a good arrangement. I'm happy to do that more often. I want to refer to some of the words that are very specifically used in the wording of this proposition, and then I'll come back to them later to explain why they're important. So the proposition specifically refers to such a scheme being for those who are in relative low-income households. That's important. And it also refers to such a scheme existing for up to 3 months, and it doesn't specify a starting date for those 3 months. So let's just set the scene a little bit here. I think the starting point to make, which I hope isn't in contention, and I know the Housing Minister doesn't contend this, but the rules regarding how social housing operates in Jersey could do with an update, and we could do with having a better framework in place for that part of our housing sector, further than what already exists in terms of some of the high-level rent policies that we already have. And work is ongoing on that, and I'm pleased to see that referred to in the recent white paper on housing. But it's still some time away from being enacted, and so I don't regard it as an excuse for doing nothing now. So just over a month ago, tenants in Jersey Homes Trust properties, of which there are 839, received letters to tell them that with just 3 weeks' notice, their rents were to be going up, and in some cases were to be going up quite substantially. Many of those homes are subject to a 5% rent increase, and many are subject to a 9% increase. None are more than 9 weeks. Understandably, that caused great consternation and anxiety for many of those tenants living in those homes, who were shocked by this, who weren't expecting it, who were offered very little time to plan for it, and in many instances had no idea, frankly, how they would pay for it. That was delayed by a month by the Jersey Homes Trust, a public meeting took place with residents of Jersey Homes Trust properties invited to that meeting. I chaired that meeting. The Minister for Housing was present too, and officers from the Customer and Local Services Department were there too, specifically to engage in one-to-one conversations with residents if they wanted to discuss their particular circumstances and what help might be on offer. And I know that they were very grateful for having that opportunity. After that meeting, I met with the chair of the Jersey Homes Trust to put to him a lot of the feedback we'd had at that meeting and what had privately come to me from Jersey Homes Trust residents that I'd spoken to. I gave that information to him simply for him to consider how he and his trustees may wish to continue. And shortly after that, we were informed that the rent increase would be delayed by another 2 months, and so it's due to come forward on the 1st of July now, in the hope that that would give extra time for residents to get their affairs in order, find what support might be available for them, and make whatever arrangements are necessary as a result of that. So that response was positive, and I was pleased that they did that. I think that their apology that they've offered for the initial short notice that they gave for it is sincere, and it's very clear that they regret how that was handled and have learnt lessons for the future from that. But it doesn't change this very basic fact, which is that there are residents in those homes who will be pushed closer to the breadline because of this decision. There will be families in those homes who simply have no idea where they're going to get this extra money from to pay a 9% rent increase. And there is either no or little government support on offer to them now. I was very disappointed to read a sentence in the government's comments to this proposition. It's the second sentence in the 4th paragraph of it, which says, in addition, any JHT tenant who is receiving income support will have any rise in rent covered by their income support payments. This is false. It is the case that plenty of tenants will get their income support payments increased to cover the rent increase, but it is emphatically not the case that they will have any rise in rent covered by their income support payments, because of potentially 2 reasons. The first of that is because not all claimants are entitled to the full income support payments because they have income from another source. For many of those people, it's because they work and they claim income support to top up their incomes because their salary isn't enough to cover all of their bills. But their salary is included when determining how much income support they're eligible for, and depending on what level it is, some of them will have a reduced income support claim, which will not be 100% uprated to cover a rent increase. Some will have their income not from working, but from their pension, because frankly they're done working, they've done their bit and are now trying to enjoy their retirement. The pension won't be uprated to cover a rent increase, but it will still be included as income in calculating their income support entitlement. And some may have some form of disability benefits. Those are people who don't have the capacity to increase their incomes independently of income support because they're either done working, they can't work, or they already are, but aren't likely to get a pay rise anytime soon. It frustrates me greatly when I see that line in these comments, because I do think it is inaccurate and it leaves people with a false impression that because somebody is a social housing tenant, then income support just pays all their rent for them. That is not true. And for many of those tenants, even if they are entitled to an increase in income support now, it might not be the entire amount, and they may have to find the balance from other income that they have, like their pension, like their sickness benefits, that they have no ability to increase, and the government won't be increasing them to cover the entirety of their income support payments. I am aware of certainly at least one family who approached me, who, and I presume this is something that might be applicable to other families as well, but who are entitled to the full rent component, but they are charged a rent in their property which is above that rent component. And so it going up means they're already at the maximum, and so they won't claim it. So I'm very disappointed to see that line in the government's comments to this, because it shows a blind spot to many people who aren't eligible for extra help. And so the purpose of this proposition is to try to target those households who, with short notice, have been told they're going to have their rent go up by up to 9%, and who are already living in relative low income, to help them for a few months whilst we consider what else can be done to support them, and to give Jersey Homes Trust perhaps more time as well to consider how they may wish to handle this. In my conversations with the Jersey Homes Trust, they have expressed a willingness to consider households on a case-by-case basis, depending on their circumstances, and potentially offer them a reduced rent increase if they can demonstrate that they would benefit from that, and that the hardship of full increase would be too great. Problem is, doing something by a case-by-case basis like that will take a very long time. It's difficult to communicate with all of those households to inform them of that and arrange to meet them and go through all of their affairs to find that. And it leaves entirely possible the chance that people will slip through the cracks and not be found through that system, and instead will suffer in silence. So with this proposition, accepting that it isn't a perfect solution would be to have a better system of regulation of our social housing providers, not just Andiam, but all the trusts as well. But that is a long time away from actually being in force. And in the meantime, we face a situation where some households in those properties are going to face greater hardship during a cost of living crisis, where they won't have the rent covered for them in the way that other tenants will do. So the intention of Deputy Southern's proposition is to ask the government to find some mechanism of establishing some support for those households who are in relative low income. So it's not well-off people, it's people who are meeting Jersey's definition of relative poverty, to have that support for a few months, whilst more can be done in the meantime to try to find a better arrangement and try to find a more tailored approach for those households. I think it is as simple as that, and I thank Deputy Southern for putting the proposition together and showing that initiative, and I hope members will support this so that we can help those lower income households in those homes whilst we find a more meaningful mechanism to support them in the future, rather than leaving them to squander for several months, having faced that extra cost which they can seldom afford. So I make the proposition, sir.
Thank you, Deputy. Is the proposition seconded?
Yes, sir.
Thank you. Does anyone wish to speak on the proposition? Yes. Deputy Miller.
Thank you, sir. I urge members to reject this proposition. The need for the proposition has I urge members to reject this proposition. The need for it has fallen away following actions taken by the Jersey Homes Trust after the proposition was lodged. Along with my colleagues on the Council of Ministers, I was concerned to hear about the sudden rise in Jersey Home Trust rents when it was first announced. I was disappointed particularly that Jersey Homes Trust had not given CLS advance notice of the proposed increase, and I absolutely agree with Deputy Mezek that that any landlord who gives a tenant 3 weeks' notice of any kind of rent increase really needs to consider their procedures very carefully and their general behaviour. That's simply not an acceptable period of notice. Any notice given of an increase in rent or any change of tenancy conditions must be reasonable, and that is not reasonable in any measure. The situation demanded action, and I was pleased to see that the Minister for Housing and Communities worked very quickly with Jersey Homes Trust to agree a 1-month delay. Since then, as Deputy Mezek tells us, and again I note the efforts of reform to hold a meeting at which tenants were able to come along and discuss their issues and meet with CLS, the Trust has reflected further and formally announced that the rent increase has been delayed to July. I would just like to highlight one particular point from Deputy Southern's own proposition, which will be relevant. Jersey Homes Trust rents were frozen in 2020 and 2021. In 2022, all rents for Trust's 839 properties went up by 3.8% in line with retail price index, and this year are being kept below RPI. We do need to recognise that many landlords had no rental income at all for over 2 years, and many of them have genuinely been trying to reflect the cost of living issues. But landlords do need to charge rents at some point. The handling of this has been poor, but we must reflect that landlords need money to maintain properties and to build new ones. Jersey Homes Trust have agreed that the July date will be an annual date for any future increases. Tenants have received 3 months' notice of the uplift in rental levels and the guarantee that there will be no further increases for 12 months. While the initial actions of the Trust were not handled well, and I am not here to apologise for them, they have fully appreciated the impact of the situation and acted quickly to remedy the position. As a result, the need for this proposition has fallen away, as there is now 3 months' notice of the increase. As Minister for Social Security, I would like to remind members that tenants in social housing properties benefit from rents that are set at least 20% below the market rate. For those tenants receiving income support, their benefit will rise, and I am assured this by officers, so I'm not quite sure where the confusion is now arising between us. The benefit will rise to cover the rent increase in full, so long as the family is occupying an appropriate sized home. Those are the rules of income support generally. In case of Jersey Homes Trust, around half of the 840 tenants already receive income support. Staff at Customer and Local Services have been working with Jersey Homes Trust tenants over the last few weeks to ensure that they receive any benefits they're entitled to, including opening new income support claims as needed. It may be that these interactions with CLS will have led to further and new claims for the community cost bonus. The Chief Minister mentioned this yesterday, and I would remind everyone who has tenants or constituents struggling with the cost of living that the community cost bonus for the 22-23 period remains open to be claimed until June. I would encourage you to ask constituents, MDU know who needs that support, to consider coming forward to claim that benefit if they have not already done so. In any event, and this is my issue, to create an ad hoc scheme to cover a particular group of tenants will create inconsistency and will set a difficult precedent. It may in fact be counterproductive to any attempt to contain increases in rent. If government subsidises rents, why would any landlord not make an increase as they see fit? Sir, to give a full picture, I would also mention that the income support system does also support private sector tenants, and the maximum support available to those tenants rose by 18% in January this year. Income support levels and the income support component also went up in January this year, again, I think by above an inflationary measure. The proposition requests a short-term scheme to support tenants for up to 3 months in response to a rent rise which was originally proposed with very little notice. That rent rise has now been delayed from April to July, giving tenants a full 3 months' notice. I can only emphasise again that those tenants who are struggling should go and speak to Customer and Local Services to see that they are being fully supported to the extent we can, but to create an ad hoc scheme and pluck things out of there will be very, very difficult for us all to manage in future. In any event, the rationale for the proposition no longer stands, and I ask members to reject the proposition.
Thank you, Deputy. Does any other member speak on this proposition? Is that a financial penalty for Deputy Farmer? Usual contribution, please. Deputy Feltham.
Thank you, sir. Before I begin, although it's not a personal interest, I will declare that my mother-in-law does live in a Jersey Homes Trust property and may well benefit should this proposition pass, depending on the rules. So if you're happy for me to continue on that basis.
Yes, of course.
But what that does give me is a bit of understanding into the situation that tenants within the Jersey Homes Trust properties may well be finding themselves in. People that are placed within the trust properties have been done so via the Social Housing Gateway. Now, very often when people are going via the gateway, it's a case of taking what may well be available. And in different circumstances, somebody may well have had a property offered to them by Jersey Homes Trust or another trust such as Laveau or an Andium property. So I do take issue with the words of the Social Security Minister when she says that the need for this has fallen away. And the reason for that is it's kind of been purely luck of the draw as to who has encountered this high rent rise this year and who hasn't, who lives in social housing. And also a number of those people, depending on when they were placed within a property, their circumstances may well have changed and their circumstances may well put them in a situation where they are living in relative low income and yet they are above the threshold to receive income support payments. And I think these are the people that will be suffering the most from this particular rent rise. And it is a real shame that the Minister and her assistant ministers were unable to attend the meeting at the town hall, and instead a middle grade civil servant was left to answer questions there and hear the stories directly.
May I? Can I just address that criticism? I passed my apologies. I had an existing appointment, as did Deputy Ferry, and we passed our apologies and those were accepted. I did not simply not attend.
I didn't agree to give way.
No, you didn't agree to give way, and the next time I think it's important that we ask the Speaker if she wishes to give way.
And just to clarify, I said it was a shame that those ministers were not there to hear those comments directly from the tenants at the house that were tenants of the Jersey Homes Trust. Sorry, I have lost my train of thought there due to that interruption. But the point I was making is that it was a kind of lottery as to which tenants in social housing have received which rental increase. So, for example, I have seen a letter from a tenant at Laveau Housing Trust. And again, I will disclose that that was my mother's letter. Laveau Housing Trust have mainly set their rents at 65% of the market rate. Their rents are lower than the residents will be facing in other properties maintained and owned by the Jersey Housing Trust. Similarly, Andium, if we compare the price of a one-bedroom flat in Andium, and actually handily, in the answer to my written question to the Health Minister, you have mentioned that the price rating of a one-bedroom Andium flat at the moment is £880 per month. The current rate for a one-bedroom flat in Berkshire Court, which is the Jersey Homes Trust property, is £943 per month. So I think we can all appreciate the difference there. Added to that, Berkshire Court, which is one of the properties that we're talking about now, hasn't been updated in many years. Whereas Westaway Court, the property that the written question referred to, has just been refurbished. So make of that what you will. So my point is that the residents in Jersey Homes Trust properties find themselves in a different position to similar people to themselves through no fault of their own. We know that we have a broken housing system. We also know from oral questions yesterday that there are currently no agreements with social housing providers. And it's those lack of agreements that have led us to a position as to where we are today and the need for this proposition to be debated. And I thank Deputy Southern for bringing this proposition. Deputy Kovac, I'm sure, will be able to provide more information with regard to social security, but I just wanted to reiterate some of the comments that Deputy Mezek made about the fact that a number of people that are living in these Homes Trust properties aren't receiving their full rent via income support. That is simply not true, and I know a number of those people. So I hope that the Housing Minister will speak and will also reference some of the stories that he heard at the Town Hall about the hardship that these people will be faced in. And I urge members to support this very short-term measure of help whilst we resolve some of those longer-term issues that still happen within our social housing provision. Thank you.
Thank you, Deputy. Deputy Scott.
Yes, sir. This perhaps is a point of clarification I'd like to ask of Deputy Mezek, because
Deputy Mezek, no, he finished speaking some time ago. So
no, okay. I'll just comment on this proposition. It's unclear to me because it says that it's asking that rent increases would be subsidised in whole or in part for a period of up to 3 months. And at the same time, I see that the press reported that Jersey Homes Trust delayed for 3 months from April until July any rent increases. So if we're talking about that period of 3 months, then it seems to suggest there are no rent increases. However, are we talking about that period of 3 months? Are we talking about a different period of 3 months or up to 3 months? So I just would like a bit more clarity about what I'm being asked to vote for. So I'd be grateful if perhaps Deputy Mezek could address that in his closing speech. Thank you, and explain why. Thank you.
So, as the Deputy just referred to me, am I allowed to clarify my own speech at this point, since she referred to it?
No, you can when you make your speech your final speech in due course. Yes, does anyone wish to speak on this proposition? Yes, Connotar of St Lawrence, and then Deputy Moore.
Yes, sir. Actually, I'd like to ask you to make it clear to us, sir, because I have to stand as a confused member of the Assembly regarding this proposition, because it is asking us to vote, I believe. I see Deputy Mezek is shaking his head, so I would like you to tell me exactly what I am meant to be considering, sir. Having read the proposition, it says whereby rent increases would be subsidised in whole or in part for a period of up to 3 months. So maybe I'm confusing myself, because we're being told that there is a delay in the rental increases being put into place for 3 months. So I listened to what I'll take this as my speech, sir, if you'd like me to. I listened to what the Social Security Minister said, and she said, don't vote for this because the 3 months is in place. The 3 months is in place because on the 1st of July, the rental increase won't come into play until the 1st of July. But now I read this again. We are being requested to, we are being asked to decide whether to request the Minister for Social Security in consultation with and as a matter of urgency to establish a scheme for those tenants in relative low-income households affected by the rent increase of up to 9%, to subsidise in whole or in part for a period of up to 3 months. Is that, I'm looking towards Deputy Mezek.
Well, the position is, if I can assist you.
Yes,
and I
please.
don't want to take anything away from anything that's been said. What you've been told by the Minister, which everyone accepts, is that the coming into force of the additional rent was delayed by 3 months. Everyone knows that. But the proposition is still asking for a scheme to be introduced to subsidise rent increases for a period up to 3 months. The proposition still stands, notwithstanding the fact that the Homes Trust has delayed the introduction.
Yes, thank you, sir. I think.
So what period of 3 months? We're talking about 3 months starting from July because we can't.
The proposition simply says for a period up to 3 months.
Okay, well, the proposition doesn't say that, so I'm afraid it wasn't clear. It could have been 3 months starting from December, whatever.
Well, it simply says for a period of up to 3 months. The proposition.
Thank you.
Perhaps the confusion has simply arisen by the fact that there's two references to 3 months, but the proposition doesn't require a great deal of interpretation. It simply stands as it is, and I'm sure Deputy Mezek will explain it again.
So I am still a little bit confused, sir, because I heard the Minister say, don't support this because it's not going to come into effect until the 1st of July, and so therefore they have had an additional 3 months to not pay their rent. So I'm going to ask two things. I'm going to ask Deputy Mezek to clarify everything when he sums up. So that is when we are able to be really clear about things, and we'll know finally, if we don't know now, which way we're going to vote. And I am going to ask the Assistant Minister for Social Security to speak. I'm sure he was going to anyway. And to clarify whether Social Security do intend at any time to subsidise in whole or in part for a period of up to 3 months the rental increase that the tenants of the Jersey Homes Trust are facing. And it seems to me from reading the report that there are tenants in 839 homes across 24 estates. So we don't know how many how many people directly are paying rental increases. It's all confusing. I found Deputy Faltham's words interesting because, of course, it is a bit of a lottery, isn't it? When you go into the housing gateway, you don't know if you are allocated a home, whether you're going to be with Levo or with Jersey Homes Trust or is it Christians Together? I can't remember the name of the other one. You don't know to which trust you may be allocated, or even indeed whether you'd be based, I think, in an Andean home, because they're gateway as well, aren't they? So, and therefore you don't know until you get your tenancy agreement at what level your rent would increase on an annual basis. So I know that the Housing Minister will probably speak to address this,
and I'm sure it's something that he will be looking at, and we will be having, I think, an in-camera discussion on it. Potentially, these are issues that can be raised at the next sitting. So, sir, from standing to ask you to clarify things, I'm not sure if I am any more certain or clear, or if I've confused members maybe a little bit, but at least I've made a contribution.
Sir, could I, sorry, but just to clarify, at the time this proposition was filed, was it that it was intended to address the period from April till July, and then the actual housing trust said those increases wouldn't contest? So the intention has changed, so it is the 3 months starting from July. I just would like that, the Deputy to address that, please.
Yes, I don't want to say too much, Deputy Scott, because I don't want to be expressing any views on the politics of this. Deputy Mezek will deal with that when he addresses you in his final submissions. But obviously the proposition itself can have no effect until the rent increases do take effect. So it has effect for the first period of 3 months when those rent increases occur in July. If that helps you.
Thank you, sir.
Thank you. Deputy Warren.
So may I allow Deputy Ferry to go first, because I think he has some more technical questions than answers than I have.
Deputy Ferry.
Thank you, sir. So just to clarify the income support question, anyone who is, provided they are housed appropriately, will have the rent increase covered by their income support payments. People who have part of their rent covered by income support will still have the increase in rent covered by income support payments. Those two groups of people are completely covered by this rental increase. Equally, there are some individuals who currently don't qualify for income support, and the effect of this rental increase will bring them into the income support net. That scheme is designed specifically to make sure that people have a standard of living, a basic standard of living that is going to be affordable for them. So all of those people, providing they are appropriately housed, will have their income support covered by the rise in rental covered by their income support payments, sir.
So may I don't, sorry sir, I genuinely don't like to interrupt because I know it throws people out. I just have a point of clarification.
I will give way.
Just quickly.
The point of clarification.
Thank you, Deputy, because I know how annoying that is. It's happened to me a lot. I just need to ask, does the Assistant Minister know how many people specifically that will be, and how many people specifically will be left without having the increase in their rent covered, because they're just on that margin? Thank you, sir.
Thank you.
Yeah, so I don't have the specific numbers, but obviously we don't know what we don't know. So we're still reaching out to JHT tenants, because until we've made those assessments, we don't know how many people will fall into the income support net. So that work is going on. But also to address Deputy Feltham's point about the level of rents, my understanding is that JHT rents are very much lower than Andium rents. They are in a position where they are trying to catch up on where their rent should be, but my understanding is that they are very much lower than Andium rents as it stands. That obviously doesn't bring comfort to people who have a budget and are working towards that, but they plan to make further investments into their properties, and part of the way that they will do that, of course, is by gradually increasing the rents. I think everyone can agree that the way it was done was not appropriate, the timing was bad, but they have taken that feedback on board and are now working closer to make sure that their tenants are at least have this brought in a way that gives them adequate notice. Thank you, sir.
Thank you. Deputy Ward, still wish to speak?
Thank you, sir. If ever there's been an advocate for an updating of the residential tenancy law, this conversation, this debate has proven that once and for all. And I'm pleased to say I really, really do hope this in-committee debate in the first week of May, I do urge the Assembly members here to read that paper. It is a really important paper because it draws out all these very issues which are being discussed here today. So just to come to the point, Social Security Minister, I absolutely back her commentary, because what we're in danger here of doing is bringing in piecemeal legislation. And this is the whole problem with the whole housing issue over the years is piecemeal, piecemeal, piecemeal. Even sadly, I'm frustrated with Deputy Mezik's proposition at the next Assembly as well, because it's a further attempt at bringing in piecemeal legislation. We've got to bring in a wholesale change to the residential tenancy law. I think it's really important to make that point. I just want to come back to those unfortunate people who were so distressed who are in the Jersey Homes Trust. I was absolutely there. I saw that distress. It was really poor showing by the management of Jersey Homes Trust, and I think that's all been recognised. Thankfully, they've taken on board my request to delay for 4 weeks and have obviously increased that by a further 8 weeks. The whole point is, and this issue around this 3-month delay has just been absolutely highlighted here. They have delayed by 3 months, and there is ongoing work with the tenants. So, work is in progress on that front, but on those points. I'm really not sure I need to say much more. I think the reality is we need to get an updated residential tenancy law in place which encompasses both social housing and the private sector, and that is what this government is intending to do. And I would like to see that new legislation with the help and assistance of this Assembly by the first quarter of 2024. So I really urge members to read the white paper, to research it. If you have any questions you want to ask me, I really encourage you to come out and ask me those questions. It's open for 8 weeks, next 8 weeks for consultation. I really urge you to read it through, because this debate has absolutely highlighted all of those issues, all of those problems, and the dangers of bringing in piecemeal legislation. I urge members to reject the proposition.
So may I ask a point of clarification at the end of that speech?
Yes.
Which piece of legislation is the Minister talking about?
Sir, I think is the potential for this proposition.
It's not legislation.
Well, what is it then? Can we explain what it is?
Can I just say, my point of clarification was the question. I'm asking the Minister, the Housing Minister, sir, which piece of legislation he just talked about repeatedly in his speech. I wonder if he could answer that.
Well, as far as I understand, sir, we are trying to make some special rules for the Jersey Housing Trust. Isn't that an amendment to existing rules? And maybe I'm misunderstanding this, sir. Maybe if you could clarify from the chair.
This is a proposition, and it's an invitation for the states to express an opinion on the creation of a new scheme. It's not legislation in itself.
My apologies in that case.
Yes. Does anyone wish to speak on this proposition? Deputy Rob Ward.
Thank you, sir. And so therefore we've just had an entire speech from the Housing Minister mentioning legislation that doesn't exist. Now that's important, sir, because we are talking about a simple short-term scheme to assist real people in their lives right now who are suffering and will have us trouble paying their rent. And no, that's been delayed by 3 months. But as an Assembly, we shouldn't be happy and go away and smile at each other and be happy with ourselves by saying, it's okay, they can be a bit poorer in 3 months' time. This is about enabling people to live their lives effectively and not face a large rent increase. And Deputy Southern brought this because he spent his entire career trying to support people that way. Now, this delays for another 3 months on top of those 3 months. And let's give you some examples. The Assistant Minister for Social Security does not know who will be assisted by Social Security yet. So for another 3-month scheme, it gives the Social Security Department another 3 months to encourage those people to come forward and assist them. That's a positive thing to do. A simple scheme to assist so that our Social Security schemes can be more effective. If it's there and it's working, not a problem. There is an issue that rents are driving more and more people onto income support, even though they're working full time. And one of the residents have said, I've heard them say, well, I can't keep taking on more jobs to pay my rent. I can't work any more hours in the day, was the line we've got. And we heard that in the evening where people came along. And so what we can do, though, sir, is we can come up with ad hoc schemes like Rent a Room and give thousands and thousands and thousands of pounds to people who already own, and will make more money out of government in order when they already have somewhere to live and they're not paying their rent, they're making rent out of someone else. That's okay in this assembly. We can do that. But as soon as it is suggested that we help a small number of people who are facing genuine hardship in the next few months, what do we get? Oh, we can't come up with an ad hoc scheme. Oh, no, we can't do that. And that, sir, is a contradiction that we see again and again and again. And I think there's a simple decision to be made in this assembly today. Let's not overcomplicate it. It is not legislation. It is a simple scheme. And I'm disappointed that that understanding isn't there. It is simply worded in the proposition. And as was suggested, this can only start when the rent increase takes place. And that's going to be in a few months' time. So therefore, 3 months when the increase takes place. And you might actually, you know what we might actually achieve here, sir, today, is to assist some people on this island with a better life for an extra 3 months. Perhaps help some of them get to social security and income support who don't want to be involved with income support because they have a great deal of pride. There's nothing wrong with income support, I totally agree. It is necessary because of the huge cost of living on this island. And often you can't work enough hours in the day in order to get by. That's where we've got to. But we can wait and we can talk about, let's not go into that. And so I urge members to really think again if you're listening to and accepting this argument that, you know, we can't do this ad hoc scheme, it doesn't work, you know, we're back to chicken licking politics again. The sky will fall in if we assist some people for a few weeks, for a few months. Now, yes, we need to address rent increases. Yes, we need to address the cost of living. And the Minister, the White Paper, yeah, great, it's got a huge number of our policies in it. Well, of course we'll accept it, it's great, but let's get on with it then. Do we need the in-committee debate, or should we just bring some legislation, let's get on with it? I don't know. To me, leadership is about bringing forward your ideas, sir, not looking for everyone else's, but there you go. That's a different thing entirely. But in this case, sir, this is a simple proposition for a simple scheme to support some people for a little while longer and help them for that extra little bit of time. It may mean that some of them can sort out their finances, I don't know. I mean, I'm sceptical about that because there's only so much in the pot that you can take out. You know, you can rearrange it as much as you want, but people are still struggling with large rent increases. And there was something that was said that I must correct. I meant to do a point of clarification. The words were used, landlords had no rental income for 2 years. Well, they did. They didn't have rental increases for 2 years. And we're talking about increases in rent. People are still paying their rent now, by the way, in this 3 months. They're just not paying the increase yet. And we could increase that today, that length of time when they're not paying the increase, if we want to take that action in this assembly. If we don't, we want to say to these people, no, you've had long enough, just get on with it, that's fine. I don't want to do that. So I urge people to think very carefully about supporting a very simple scheme to help real people in their lives right now and for an extended period of time. Thank you, sir.
Thank you, Deputy.
Call for the adjournment, please, sir.
Chairman's proposed.
Who wants to speak? I'll finish.
Is there?
I would like to propose, if there's not too many members, that we aim to finish.
Well, can I?
Before the lunch recess.
Can I, perhaps to assist, can I invite members who wish to speak in this debate to put their lights on so I can take a note of how many there are? So how many more members wish to speak in this debate? If you've got any, it's Deputy Kovacs wishes to speak and Deputy Farnham. So just 2 members left to speak. Do you want to take your proposition?
I'm happy to withdraw the proposition.
Yes. So Deputy Farnham, your proposition is to continue.
It is, sir.
Is that seconded? There members to speak on that proposition? That proposition then is adopted. There's no objection. Deputy Ayer. So forgive me, Deputy, you can speak. Deputy Kovacs, yes.
Thank you, sir. I won't be long. I just want to clarify the points about the income support, because the ministers have maintained that anyone that is on income support and suitably housed, then their full rent increase will be met, as in their comments. As someone that worked in income support, I can confirm that's not correct. Jersey Home Trust, although it's seen as social housing, it doesn't have the same cover for housing like the Andium, which has a different regime. For Jersey Home Trust, they are, like with social housing, there are thresholds on the accommodation that are met, but with the Jersey Home Trust, you take the component increase, you don't cover all like with Andium, and what it's then put in the final outcome that it's entitled for income support, it's addressed. So from 100 to 100 increase in rent, the people that are income support on Jersey Home Trust, they might just get a few pounds extra on it. So that's all I wanted to clarify. Thank you.
Deputy Farnham.
Thank you, sir. I just wanted to be absolutely sure. This is simply requesting some financial support for just 3 months to help tenants through. And the total cost of that is likely not to exceed £250,000. Thank you, sir. I just wanted that clarified. Thank you. That could be clarified in the...
Yes. With no other wish to speak, I invite Deputy Mezek to reply. Deputy Mezek.
Thanks, sir. In response to the last speaker, yes, to both counts. Hopefully that's clear. So can I start by apologising to members if in my opening remarks I wasn't clear enough. I can see that some confusion was caused by the wording of some of this. I did clarify that in the wording of the proposition, when it refers to a period of up to 3 months, it doesn't itself in the proposition specify a starting date. It refers to rent increases. So I think it's implied that the starting date is the date that the rent increases, whatever that may be. At one point it was to be the 1st of April, another point it was to be the 1st of May, and now it's to be the 1st of July. So I think the wording gave the flexibility to give a starting date at the point at which the rent increases. So that is the time period. And that's why, sir, it was extremely disappointing that the Social Security Minister started her speech, and I wrote down these words to be absolutely clear when I referred to them. She said, the need for it has fallen away. No, it has not. It simply has not fallen away, because on the 1st of July, there are people in our community who are suddenly going to be hit with a big rent increase that they don't know how they're going to afford. A rent increase being delayed by 3 months for those people is not that much consolation. To be told you're going to be poor from the 1st of April, oh no, wait, you're actually going to be poor from the 1st of July, is not that much consolation. It's a slight reprieve, but certainly not a permanent one. And I really can't stress this point enough, and Deputy Kovacs helpfully explained this as well. But it is not the case that income support foots the bill for all of these people. It just isn't. They will for lots of them, and that's good. And I've already spoken to some of those tenants who have taken their notice of rent increase to CLS, showed it to them, it's all been sorted, no problem. But But it's not the case for everyone. For some people, some complex calculations will have to take place to take into account what income they're getting from another source, like their pension, like their employment income, like their disability benefit. It will go through some calculator, and the figure that comes out at the end of it will not be the full amount that their rent has gone up by. The outstanding balance from that will have to come from somewhere, and for some of those people, they haven't got a clue where that's going to be because they're already towards the breadline. This proposition specifically refers to helping those who are in relative low-income households. The term relative low-income is a euphemism. It means relative poverty. That's what it means. It means people who are already living beneath 60% of median income in Jersey. These are people who are struggling, who don't have the agency to increase their incomes through other mechanisms, and what mechanisms currently do exist aren't going to support them fully. This is people who will have to make some very difficult choices for their budgeting. People who frankly already do have to make difficult choices because they're probably already in rental stress. They're unable to increase their incomes from other sources. And we hear stories, I've spoken to parents who are concerned about how they're going to provide the best upbringing possible for their children because they won't be able to afford things to support them that they already struggle to support them with, whether that's new clothes, whether that's the healthiest meals they can prepare for them. They're already struggling. So that is who this is about. I beg the Housing Minister if he can just try to do a bit more homework before coming to these States Assembly sittings, because he referred multiple times in his proposition to piecemeal legislation, and this debate is not about legislation. Complete red herring. There's nothing in this proposition that refers to legislation. He made a reference to, frankly, an irrelevant reference to an upcoming proposition that I've lodged that he describes as piecemeal legislation, which is not piecemeal legislation because it refers to wider work that's going on for those elements to be slipped in. It specifically refers to the wider work to be a part of it, so it's not piecemeal. He really ought to do his homework before coming to this assembly and making inaccurate statements like that. Sir, as things stand, there are some people who are going to find their lives more difficult from the 1st of July. And we have the ability, with in the context of all of our government spending, a very small amount of money that could be allocated to provide some reprieve for them for a few months, whilst some more work can be done to target those people who may end up suffering hardship because of this, to help them find those solutions and to help them get into a better position where this 9% rent increase isn't going to hurt them so much. We find amounts of money for all sorts of things to spend on. Deputy Ward referenced some to do with the rent-a-room scheme. You know, nothing to do with hardship in that. And now we're talking about hardship, and suddenly that is so controversial. We can easily source that if we choose to, and then get the wheels in motion for a scheme to be put in place temporarily to help those people a bit more. I'm disappointed that we have a debate where so much misinformation has been allowed to purvey into this debate, to confuse things, say things like the need for it has fallen away when it hasn't, to talk about piecemeal legislation when this isn't about piecemeal legislation. This was meant to be a debate about whether we help some of the poorest people in our community to be relieved for a little bit longer whilst better solutions can be found for them in the meantime. And I hope if members understand that point of what this proposition is about, understand that there is need, that it is not all covered by the systems that currently exist, and that with no action, some people will simply be a lot worse off and there's nothing they can do about it and it's not their fault. That's what this ought to have been a debate about, and I hope if members would like to see something done to help those people, then they feel that they can vote for this proposition. But I certainly ask them not to vote against a proposition on the basis of a misunderstanding of what it's all about and who the people are who are actually affected by it and their circumstances. And so I call for the appel, sir.
Thank you, Deputy. The appell has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members present and joining remotely have had the chance to cast their votes, then I ask the greffier to close the voting. The proposition has been rejected. 18 votes for and 23 votes contrary.
The names, please, sir.
Yes.
Those members voting for, the Connétable, St Lawrence, St Martin, St Clement and Grouville. Deputies Tadier, Luce, Rob Ward, Owls, Farnham, Mesick, Coles, Porre, Feltham, Kovac, Andrews, and the Connétable of St Ouen and St Saviour, and Deputy Jeune. And the members voting contre, the Connétable St Brelard, Trinity, St Peter, St John and St Mary, and Deputies Morel, The Hegera, Ayer, Gardner, Gorst, War, Miles, Scott, Renouf, Miller, Al, Tom Binet, Ferry, Alex Curtis, Barbara Ward, Wilson, Stevenson, and Rose Binet.
Thank you, greffier. That concludes public business for this meeting, and I invite the chair of PPC to propose the arrangement of public business for future meetings.
Thank you, sir. The arrangement of public business of the 2nd of May 2023, there's been one change since the publication of the consolidated order paper. The amendments to standing orders governing remote participation have been lodged and listed for the 23rd of May. For the next meeting, I understand that the Minister for Housing and Communities, would like to dedicate half a day to the in-committee debate. In light of this, and even though there is only one proposition, Rent Control Measures P18-2023, lodged by Deputy Mesick, listed for the next time, members should expect to sit on the Wednesday. Thank you, sir.
Members content to proceed as proposed by the chair of PPC in respect to the next meeting of the Assembly? Accordingly, the states stand adjourned until Tuesday, the 2nd of May at 9:30 a.m.